of India Act, all other subsequent constitutional frameworks, constitutions that we have had, there was always legislative power. There were always, the rules were always subject to law and constitution.
Our 56 constitution.
56 constitution, in fact, went a step ahead.
उसकी language फर्क है.
Ji, 170 said that until an act of parliament is made in this behalf.
That's a different language.
So it was actually, it went a step
But
further.
after, what happens after?
And then subsequently 62 and 72, it says subject to the constitution and the law with the prior approval of the president. So what is happening here is, and barring Government of India Act.
Government of India Act.
Government of India Act was totally prior approval in his discretion, and that's about it.
No, but Government of India did not have any legislative engagement at all.
Yes.
So what I'm saying is, if you look at it in the historical context, and I'm now focusing on the analogy that you're making, that previously there was the executive plus the legislative. The executive was purely passive as far as I can understand. So why should not, on that analogy, the law-making power or the law part of it also be regarded not as an enabling power, as a whatever restrictive, limiting power, or whatever in whatever sense?
One reason perhaps could be that till 1972 or when the 1956 rules were made, because there was a prior approval of the president already there, the legislature chose, and in fact, in 1956, because third schedule applied, until such time it applied when the parliament actually made these regulations, to the exclusion of, in fact, the Supreme Court, the 1956 constitution, it did not. So there was, the parliament chose not to act. What I'm submitting, my lords, is that parliament's choosing not to act or choosing not to act does not, or it cannot be inferred that the parliament has given up its right.
No, but on the analogy that you make, then the fact that parliament since 1973 did not choose to act, well, you can go back to 1962, I guess. Certainly since 1973 it did not choose to act, but is not an indication that Parliament has given up anything, but is an indication that Parliament has recognized that this is not an enabling power.
My lord, that would then giving a meaning to,
and therefore there was nothing for Parliament.
And that is why I had referred to Articles 4, 20, 22, and 28 to submit that the term law, or in 19A when it is
there, Mr. Attorney General, the use of the word law over there, I think, has to be read with Section 8. Because Section 8, Clause 1 is the controlling section which says the state shall make no law. Right?
Article 8.
Article 8. Shall not make any law which violates them. And then when you look at the fundamental rights and where it says subject to law, that takes color from as an exception to what is prohibited by Article 8, Clause 1. So that's perhaps, I mean, I'm putting this question to you, that the analogy that you seek to draw from use of subject to law and fundamental rights perhaps is not correct, because the context over there is totally different.
My lord, if I may, now Section 8, Article 8, Clause 2 places a barrier on the state to not make laws which in any way abridges these rights. But what in turn Article 14, this language in Article 14, 20, 22 and 28 is doing is it is actually enabling the parliament.
It is for actually restricting.
No, restriction is there in under Clause 2 of Article 8. Restriction is there and here it is enabling.
The reason why it is enabling is because it seeks to balance the overarching restriction imposed in Clause 2 or 1 of Article 8. But that is not the position over here in Article 191. So the analogy that you seek to draw, or the assistance that you seek to draw from the use of this phrase in those fundamental rights, perhaps is not correct. What would you say to that?
My lord, the language in Clause 2 of Article 8, when read with what is provided in Article 14, and if I may just now read it out. Clause 2 of Article 8. It says that state shall not make any law which takes away or abridges the right so conferred. And then, so this is a broader constitutional statement, a requirement that no laws which abridge those rights.
Guarantee blanket prohibition.
Blanket provision. But the carve-outs in Article 14 there.
So that the carve-outs therefore are to enable. This is
Yes.
this is, you
Yes.
cannot do it at all, so that may be then regarded as enabling.
Yes.
But even over there, it is not to destroy, it is
No,
to
no, that has to wait. This has to wait, whether the destruction part has come into
But
force or not,
190
but this has to wait.
But 191
When
is
I
to-
come to independence
No,
of
but
judiciary,
my
this has to
question-
wait.
My question still stands. 191 is totally different.
No, no.
What analogy do you, what assistance do you draw from subject to law?
Exactly
using-
what my lord has just pointed out. It is enabling provision.
No, but it is
Enabling and in the context. Now, in the context of what you just said.
उसका काउंटर फिर क्या है ना? देखिए, जो सब्जेक्ट टू लॉ फंडामेंटल राइट्स में इस्तेमाल हो रहे हैं, दे काउंटर बैलेंस आर्टिकल 8.
Yes.
ठीक है
And Article 191's
191
counterbalances independence of judiciary.
Sorry?
Article 191's counterbalances independence of judiciary.
So the
That
independence.
no law which affects independence of judiciary, and that is why I had
This is your
submitted, please
submission.
wait for this submission on independence of judiciary. That might just answer what you just pointed out.
See, if you're saying the counterbalances the independence of the judiciary, that is the entire argument here.
So इसीलिए उस पे जरा
That
वेट
this
कर लें कि मैं जब उस पे
legislation
सबमिशन करता हूँ तो that might just
एक
address it.
बात तो ये है कि this legislation affects independence of judiciary.
But मैं ये
And
इस पे
if-
अभी आपके
if
observation.
it comes to, we come to the conclusion that that it does, then obviously the restriction that 191 places is correctly placed, number one. Number two, the word law appears in the Constitution more than 200 times.
Yes.
Now, are you arguing that wherever the word law is used, it is used only in one sense, and that is an enabling sense? Or is it more accurate to say anywhere where it is used, like you have just read Article 8.2 and 14 and 20 and 24, it has to be read in that context? It's one fits all, one size fits all नहीं है.
As I submitted,
हर जगह जहाँ लफ्ज लॉ लिखा हुआ है उसका एक ही मतलब नहीं है. You have to contextualize
मैंने
it.
at the outset, when I said that law's two sources, which is this positive law and act of parliament and the judge-made law, so these are broadly two sources of law which the constitution recognizes, which our jurisprudence recognizes. So these are the two sources which we will apply whenever the term law appears, and then see which of the sources fits it. Now let's turn to Article 192.1 and compare it with Article 176.
Before going to that article,
Mr. AG,
you are talking about
the
Article
purpose?
8 of the, Mr. AG, please, you are talking about Article 8 of the Constitution,
first, hear
which is
Mr. Mendoza.
in chapter number 1, which speaks about fundamental rights. See, subclause 2 of Article 8 says, which takes away or abridges the right so conferred. Which right this article is talking about?
The fundamental rights, my lord, in the chapter.
So the
Article
law
9 through.
Any law should not be in contravention or should not take away the fundamental right of the.
Yes, so my submission
So
was
whether-
that this is the broader restriction which the Constitution places and then enables under Articles 14, 22 to then subject those rights to the laws which may be made in.
Here question for you is that the law which is promulgated, present law, this takes away the fundamental right of a people of independence of judiciary and their, to secure their right through independence of the judiciary. This is the question whether it takes away or it not takes.
Yes, so that is why I had submitted that when I address the independence of judiciary and also separation of powers, both concepts sort of intertwined in the constitutional sense, so that this question might be adequately addressed at that time, and that is the barrier. Now, if my lords may kindly turn to quickly to 176 first, Article 176 first, my lord.
I just want to ask, because for last 5 days there is a confusion, the using of word law in Article 191. Then if it is used, then what is the purpose?
Yes.
What is the purpose of using this word? Why not only Constitution?
Yes, yes. Now,
And learned Attorney General, it is not just law, it is subject to law. So that is what is more important.
absolutely, I'm coming to it, my lord. First, Article 176. Need not take you lordship through it. This is about the number of judges. Now, it says that the Supreme Court shall consist of the Chief Justice and the judges as determined by an Act of Parliament. So the term used is Act of Parliament. Now, if my lords may kindly turn to Article 192, Clause 1, which is in relation to high courts. Here it says,
Which one?
192 clause 1. Here it says the High Court shall consist of Chief Justice and so many judges as determined by law. Now, in these two provisions, there are two different terms which have been used, but what are we to make of this term law used here? To my mind, it can only be an act of parliament. It perhaps can't have that other source read into it that if the, let's say, the Supreme Court gives a judgment.
You are saying it means the same thing or they means different things?
My lord, in my respectful submission, in the context of Article 192(1), the term law is to be treated as
But why
an
can't
act.
it, but why can't it mean act of provincial assembly?
It could be.
No, this
It is. I thought about it. I thought about it. But then the problem is that the Constitution, because under entry 55, when it is jurisdiction and powers of all courts, and in that context,
that's the concurrent list where the provincial assemblies. You see, the problem of saying what you are saying is in relation to 192. Law means act of parliament. Is that it then relates to entry 58. And entry 58 says anything which is in the competence of parliament or relates to the federation
yes.
is exclusively in the federal domain. Provinces can't make any law. Now, surely a province is entitled to say, well, sir,
We need more judges.
no, we're not we need more judges. That a high court, it may be a matter relating to the federation, but it also relates to a province. How can you relate law over there as act of parliament, read it with entry 58 and just wipe us out of the picture? No, but वकील साहब,
मैं इस पे आगे आने लगा हूँ ना।
अटॉर्नी जनरल साहब, इसमें एक मुश्किलात है ना। अब सवाल ये उठेगा, अगर दोनों हैं तो फिर कंकरेंस है तो फिर पैरामाउंसी है। देखिए, जो क्वेश्चन दैट माय बात सुन लें, द क्वेश्चन दैट माय लर्नेड कॉलीग पुट टू यू, वन साइज फिट्स ऑल नहीं चल सकता यहाँ पे। यूज ऑफ द वर्ड लॉ कैन हैव सो मेनी शेड्स ऑफ मीनिंग। तो आप जरा
इसको हम एड्रेस कर लेते हैं। इसको इट्स इजीली एड्रेस
करने की जरूरत नहीं है, लेकिन आई एम जस्ट पॉइंटिंग आउट द डिफिकल्टी।
I thought about it that why can't it mean an act of provincial assembly, but that need not detain us for the purpose of Article 191 because there the Supreme Court is exclusively
There's no doubt
outside
about
of
that,
this.
yes.
So therefore, for the purposes of 191, there is a confusion here. I thought about it, but then I stopped thinking about it for that matter because 191 के लिए relevant नहीं था.
नहीं, but
But in any way, in any event, it would be an act of parliament or
नहीं, but why don't you say it is intentional by the framers of the Constitution that one place it is by act of parliament, surely there it could not be by law. So we are agreed there, I hope. And the other one, the parliament kept the door open, whether it would be parliament itself or it would be the provincial assembly, without fixing it, because maybe the framers of the Constitution wanted to make the Constitution a living, breathing organism which can, depending on the situation at that relevant time, they have put Act of Parliament, then it would have fixed it and Provincial Assembly would have gone away. Or if they have put Parliament or Provincial Assembly, they may not have wanted to do so. So sometimes ambiguity is intentional. It is not that they made a mistake or didn't think about it. I would consider that if they use the word law there, we don't need to address that in this case, but it is the only thing which comes out clearly is that the first one is fixed by the Parliament and the other one by law, which could surely not include judge-made law.
and it
I mean,
would
I would think that would be a stretch if we say, no, it could also include judge-made law.
And
I don't know.
If I may, it should surely be an act. We can debate which assembly or the parliament that we can park it aside for the purposes of these proceedings. But what it surely does is that for the purposes of Article 191, an act of parliament cannot be
So it's the
excluded.
context
That's
which
a
has to be
starting
seen.
point,
The
yeah.
context is
cannot
relevant. I think the language is used in context. The words should not, don't mean, the same words can mean very different things used in different contexts.
The point that I'm trying to make through
If the
this is that
starting
an
point
act
is-
of parliament is included, is covered in the meaning of
That's
term
the
law in
starting point,
191.
that's-
191. Now, before I,
Attorney General, you were just referring to 192, and you said the word law is used here, but देखें उसका context क्या है? The High Court shall consist of a Chief Justice and so many judges as may be determined by law. ठीक है? अच्छा, अब उसको आगे क्या उन्होंने qualify कैसे किया? Until so determined. इसमें क्लियरली इंटेंशन है कि जी लेजिस्लेटिव कंपेटेंस वो दे रहे हैं कि आप जब तक वो लॉ नहीं बनाते तो प्रेसिडेंट डिटरमिन करें. There is no such phraseology used in 191. It doesn't say until such law is made.
there is a reason for that.
Yes.
The reason is because in both 1962 and 72, the identical language appeared. And when 93 constitution commenced, we already had the rules. So there was no reason for anyone to determine anything because there was already something in existence.
So obviously
Unlike this
इसमें
situation
ये
perhaps.
कहा जा सकता था ना, अगर ये इंटेंशन थी कि जी the Supreme Court may make rules regarding regulation of procedure and practice until law is made or a law is promulgated. ठीक है? उसमें लेजिस्लेटिव कॉम्पिटेंस कन्फर कर रहे होते कि जी सुप्रीम कोर्ट अगर रूल्स बना भी लेती है तो आप अगर कानून बना देते हैं तो इट वुड ओवरराइड दोज रूल्स. नाउ दैट इंटेंशन इज नाइदर एक्सप्लिसिट नॉर इम्प्लिसिट in the language of 191.
My lord, my respectful submission is that it is not so.
जहाँ उनकी इंटेंशन थी कि जी लेजिस्लेटिव कॉम्पिटेंस ग्रांट करने की, वहाँ लेजिस्लेटिव कॉम्पिटेंस एक्सप्रेसली ग्रांट की है.
My lord, I'm going to come to that, but let me first address the question that you had previously raised, and let me just deal with it because when we look at the term law, we have to give it some meaning. Some meaning to it. I have submitted that there could be two meanings to it. One meaning is an act, other meaning is a binding precedent. I'm going to deal with it when I address the question of convention. But let me first take care of the 1956 rules being existing law and then proceed with it.
Do you have attached the rule 1956 in your paper book, 1956 rules?
My lord, this may kindly be recorded, my lord. This is something that I thought about later, so this may kindly be noted. Now, 7 of Article 268 does include within its meaning rules, bylaws, regulations as existing laws. And then clause 1 of Article 268 tells us how they shall be dealt with under the new constitution. I'll just read out 268 clause 1 and then take your lordships back to 191 and then the rules of 1980. Clause 1 of Article 268, it says, except as provided by this article, all existing laws shall, subject to the Constitution, continue in force so far as applicable and with necessary adaptations until altered, repealed, or amended by the appropriate legislature. Identical language in 270AA6, which deals with anything and everything that had happened prior to omission of or concurrent legislative list
Sorry,
after the 18th
I'm not
Amendment.
following it. Are you saying that Article 268(1)
Ji.
saves laws which
And
which existing laws which it goes on to define in sub-clause 7, but specifically excludes decisions of the Supreme Court or the High Court? Are you saying that?
No, what I'm saying
But
is,
this definition of law does not say and decisions.
मैं अभी उस पे आता हूँ सर. मैं यहाँ पे ये कह रहा हूँ कि जो existing laws थे उनको save किया.
Yeah, but when
Granted.
we're using the term law, because sometimes you said it includes decisions. So, but this article does not
This is
mention.
independent of my earlier submission, मैं यहाँ पे उस point को address कर रहा हूँ जहाँ पे my lord की observation थी
नहीं
Justice Ijaz की।
मैं वो बातें नहीं मैं आपसे सवाल
वो
स्टैंडर्ड
तो नहीं
सवाल
होगा
कर रहा हूँ। मैं ये कह रहा हूँ कि does this mean that this is the starting point and we are not, the courts are free of earlier judgments because existing laws does not specifically mention decisions of the superior courts or of any courts?
उसमें my lord perhaps 189 का effect
No, perhaps
आएगा।
नहीं, मगर
189 का
अगर
effect
आपका
so
लॉ
long
आप
as
उसको एक्सटेंडेड मीनिंग दे रहे हैं तो यहाँ आप उसको रिस्ट्रिक्टेड मीनिंग दे रहे हैं।
provisions which survive will
एग्जिस्टिंग
have to
लॉज
be
की
read.
डेफिनेशन
हाँ?
दी हुई है एजी साहब,
The provisions
एग्जिस्टिंग
which
लॉज
survive-
की
Clause
डेफिनेशन
जजमेंट्स का तस्करा नहीं आ रहा है ना।
नहीं आ रहा ना, वो 7 में डेफिनेशन
उसमें-
पढ़ लीजिए
उसमें ये
आप,
होगा definition-
एग्जिस्टिंग लॉज की
जी
सब आर्टिकल 7 पढ़ लें।
जी
इन दिस आर्टिकल एग्जिस्टिंग लॉज
means
मींस
all laws including ordinances, orders in council, orders, rules, bylaws, regulations and letters patent
शायद इसलिए भी
constituting
ना
a high
कि
court and any
Mr.
notification.
Attorney General, this is a saving clause, so they could not have referred to the judgments. It is a saving clause, could only deal with laws.
Laws and so long as the
Ordinances.
laws continue, the effects of the
Why are
judgments
we
continue.
categorizing it as a saving clause?
My lord,
No, tell me from the text why are you categorizing it as a saving clause?
my lord, giving continuance to the laws which were in field.
No, but
because
if you read it with sub clause 1,
Ji.
it is nothing saving about it.
no, what it is doing is it is in order to ensure the continuity of system. It is
Part of the
permitting those laws to
देखिए, if that
continue
is the
till such
argument,
time.
if that is the argument, then continuity of the system surely requires judgments to be sustained as well.
मैं उसकी जरा थोड़ी सी ये submission complete करूँ, ये confusion.
Okay.
Then let me just complete my submission. My lord, my submission, and then let me just now state what my submission is before I come to explaining it. My submission is that the term law used in 191 cannot possibly include 1956 rules. And I say this because if
Existing laws did not include.
the term law in 191 used in Article 199 cannot include 1956 rules. Because this is the observation, this is an observation made by my Lord Justice.
Kindly repeat that, I'm
Yes.
missing it.
The
1956
term law used in Article 191 does not include
1956
an existing law, which is to say the rules of 1956, the Supreme Court rules of 1956.
Does not include 1956 rules.
Why? Why? Now, if we turn to clause 1 of Article 268, and if I may reread it.
Before going to that, if you read Article 75, please read that, that is, I think it is relevant. And specifically sub-article 3. Yeah, देख ले इसमें, what is law? It has been defined.
लॉ को वो कह रहा है कि जब वो एक्ट
आप पढ़ लेगा ना?
जी जी मैं उस
Oh, this,
मैं आ जाऊंगा।
under sub-article 3, it is stated when the president has assented to, it is deemed to a bill, it shall become law and be called an act of
Parliament.
Majlis Shura.
Yes.
So, if it is assented by president, the law is an act of the parliament.
मैं सिर्फ ये तो मैं ऐसी एट द बता चुका हूँ। मैं इस वक्त उस क्वेश्चन को एड्रेस कर रहा हूँ जो ये आया था कि जी एग्जिस्टिंग लॉ बिकॉज 56 के रूल्स एग्जिस्टिंग लॉ हैं एंड 191 के नीचे वो लॉ की उसमें आ जाएंगे एंड देयरफॉर जो हमने सुप्रीम कोर्ट ने रूल्स बनाए हैं they are perfectly all right, they could only be
Mr. Attorney General, if I have understood you correctly, you say the term law used in Article 191 does not include the 1956 rules.
and not include 1950 rules as existing law,
No, but my question to you is, are the Supreme Court rules 1980 currently framed, are they law?
No, not within the meaning of 191. No,
Ji?
not within the meaning of 191. And let me please try to explain it.
I'm saying,
इसको explain कर लेने दे ताकि at least वो question address हो जाए.
Neighbor,
obviously
one
the
word
argument-
answer is no, they are not law.
They cannot be treated as.
obviously
they
they're
cannot
not
be
law
treated.
within the meaning of 191 because otherwise the argument is circular. How can this,
Yes,
I mean,
yes, my lord is right.
but
My lord can complete what
leaving
you're
that
saying.
aside,
Yes,
no,
that's right.
leaving that aside, I'm still curious. Are the rules, forget 190, the use of word law in 191, My question is more general. Are the Supreme Court rules 1980 law or not?
Supreme Court rules 1980 regulating practice and procedure cannot be called law within the meaning of 191. So
But
to that
isn't,
extent,
isn't
I-
it
doesn't
law
answer
under
my
the
question.
constitution?
That doesn't
Under
answer.
the constitution, say, says not by or under the constitution. This is something mandated under the constitution. It
Would you-
derives, its,
Are your rules of are your rules of business made under Article 99? Are they law?
मुझे एक चीज
हाँ मुझे बताइए.
मुझे एक चीज
अरे अटॉर्नी जनरल साहब,
एक
you have
चीज
made
जरा
a
मुझे
very
address कर लेने दें.
extraordinary statement, which are the rules of business made under Article 99 law or not?
My lord, my submission is that in the
Give me a
broader
straight
sense,
answer
in
to
a
your-
broader sense, yes, they would be, they would have the
Are the-
meaning
are
of
the
law for the
rules-
purposes of regulating
Are
the
the
business of
rules
federal
of the
government. Yes.
are the
Yes,
rules
yes,
of the
yes.
National Assembly rules of
Yes.
procedure made
Yes.
under Article
Yes.
60?
My answer to your question was that for the purposes of 191,
That
they
was
cannot
not-
be called.
But that was not my question.
Generally speaking, yes.
Vakil Saab, that was not my question.
Sir, मैंने कहा generally speaking, yes.
Generally
That's my
speaking,
answer.
नहीं, एक
But-
generic question आपसे
मैं अभी तो एड्रेस कर रहा हूँ और चीज, अभी मैं एड्रेस ही और चीज कर रहा हूँ, अब आप उसको और
कॉन्स्टिट्यूशन
से जाएं।
ने लॉ रूल मेकिंग पावर दी है एग्जीक्यूटिव को भी, लेजिस्लेचर को भी, सुप्रीम कोर्ट को। सवाल ये है जो एग्जीक्यूटिव ने अपने रूल्स ऑफ बिजनेस बनाए हैं इन एक्सरसाइज ऑफ पावर्स अंडर द कॉन्स्टिट्यूशन, आर दे लॉ?
Yes.
यस। जो लेजिस्लेचर ने अपने रूल्स ऑफ बिजनेस बनाए हैं, आर दे लॉ? If they are law, then why are the rules of business, framed by the Supreme Court in exercise of powers granted by the Constitution, the same powers which the legislature has, the same powers which has the executive has, not law?
इसी को ही मैं एड्रेस करना चाह रहा हूँ।
जी करें।
आपने कहा कि जो हमारे रूल्स थे 1956 के,
56 को जो 80 की बात कर रहे हैं।
उसको नहीं, उसको अगर हम एक तरफ रख दें, तो at least we can
Leonard
address, we can
Attorney
take care. I need not make any further submissions on them being existing law and thus the term law including those, meaning those 1956 rules. If that is accepted, I need not make any
No,
submissions.
I'm not accepting. What I'm saying is, आप 80 के rules की बात करें, वो law हैं या नहीं है?
मुझे आप पहले वो एड्रेस तो करने दें, अब आप उसको एक्सेप्ट नहीं कर रहे, मुझे फिर सबमिशन उस पर कंप्लीट तो करने दें।
If I've understood you correctly, you say 1980 के जो rules हैं वो under the term law आते हैं. However, in the context of 191, you cannot consider them as law, because then the entire
Contradiction
process,
है.
then there will be contradiction within the letter of Article 181.
Absolutely,
ठीक है?
absolutely, my lord. And यही contradiction है जो उस argument में है या उस point में है कि जी वो because existing laws में आते
नहीं,
थे,
but वकील
क्योंकि
साहब, एक जरा kindly, Attorney General sir, you're making, speaking for myself, an extraordinary submission, so I want to be sure I understand. Now, you say 1956 rules are not existing law, but you say that the Supreme Court rules of 1980
no.
are law in the broader sense of the term, right?
Please rephrase me, let me rephrase myself. What I said was that they would be existing laws, covered under 268(7), but they can be termed or treated as law within the meaning of term law used in 191. That's what I'm
मैं
saying.
समझ गया हूँ बात, but the reason I'm asking this question is that Rule 1, Sub-Rule 2 of the Supreme Court rules, which you say is law, specifically says the Supreme Court rules 1956 are hereby revoked.
Yes.
So both have to be law. Both have to be law. Otherwise, in 1980, the Supreme Court could have said there are no laws. The Supreme Court rules of 1956 never existed. They ceased to exist when this Constitution came into being. We don't need to revoke them.
So
अरे
what
आगे
then this
बात
means
तो-
is,
अरे,
मैं
I
आपकी
need
बात
to
तो समझ
understand.
गया हूँ, but
नहीं, आप मेरी सबमिशन तो जो आप फरमा रहे हैं मैं उसको समझने की कोशिश
जी
कर
मैं ये कह रहा हूँ,
अरे बात तो सुन लेना। आपने जो आर्टिकल 268 पढ़ा, that says subject to constitution.
and
So it is possible, is it not, that the 1956 rules were existing law,
yes,
but the power to amend existing law within the meaning of clause 1, Article 268 was subject to the Constitution. The rules of 1956 were the rules applied in terms of the rule-making power, not law, rule-making power of Article 191, and therefore, the same shouldn't say problem, issue I would say, in relation to any legislation affecting, amending, restricting, repealing, whatever, the 1956 rules applied as it does now in the context of this proposition before us, this act versus the 1980 rules, exactly the same position applied. Would you agree with that?
Yes. Yes.
Yes.
Yes.
Thank you.
And that is why,
Thank you.
that is why I would just conclude by this submission by saying that when existing
आपने
laws
जो पूरा
but
अपना
cannot-
बहस आपने जो पूरी अपनी बहस शुरू की है वो आपने किसी और बेसिस पे शुरू किया आप अपने आर्गुमेंट्स करते तो ये सारे मसले आपके खड़े नहीं होते but
I am
sometimes
just
sometimes
saying-
it is not very easy to give a yes no answer. It
What
was
I'm just saying
it
is-
was like the young on a lighter note जरा माहौल भी जरा ठंडा रखते हैं.
अच्छी बात है सर.
On a lighter note, a lawyer was battering a lady during cross-examination. No, sorry, the husband representing the lady, and he said, "Have you stopped beating your wife? Answer yes or no." So keep it things light and move ahead.
So I'll just conclude my submission, this submission, by saying that the 1980 rules or the 1956 rules, though they were existing laws when the Constitution came in, but saying that they were the law within the meaning of Article 191 would be a contradiction.
Okay, can I ask a question?
आगे चलता हूँ.
ये एक सवाल सुन लें कि आप ये कह रहे हैं कि वैसे तो the rules are law, but for the purposes of 191 they are not law. Now wherever the word law has been used, what principle of interpretation will be applied to see whether these rules or any other rules will be applicable there in the term law or not? The reason I ask this question is that the first day, what my question to you was that if subject to the Constitution and the law meant law just an act of parliament to the exclusion of everything else, then maybe the word law was not the right word. So when we look at the word law, we have to read something more than just an act of parliament. So the act of parliament is there, but other things are there. Now you are saying उसमें से आप ये rules निकाल लें because यहाँ rules नहीं apply होंगे. Then in some other provision rules डाल दें because वहाँ rules apply होंगे. So there doesn't appear to be any principle of law that one is following on the basis of which one would determine where to use what part of law.
इसमें learned attorney general, since this discussion is in the context of Article 191, can we construe Article 191 that the rules may be made by the Supreme Court subject to the rules that it will make? This is the simple question. You
इसमें
see,
एक बात
it
और भी है इसमें.
automatically excludes the rules that will be made.
My Lord Justice,
Because it is in the
Justice
context
Afridi
of
made an
Article
observation and that
इसमें
sums
एक
it
बात
up.
एजी साहब और भी है, what I understand from the questions of the learned colleagues, that is subject to the constitution and law, obviously the Supreme Court may make the rules. Once the rules have been framed, and maybe this may be included in the definition of law, but whether there is any sunset clause after making rules by the Supreme Court, the word law has become redundant. Is the purpose then?
Yes.
If we are talking on it, then once the Supreme Court has made the rules, that has become the end of the story, and they cannot make further rules.
Attributing redundancy.
And the redundancy attribute हो रही है ना, अगर हम उसको करते हैं कि Supreme Court rule बना सकता है, Supreme Court has made up the rules. Then what is the purpose of the law used in the Article 191? Because there is no sunset clause. After making rules, obviously it will be a sunset clause for that. जैसे आपने नीचे पढ़ा है ना कि वो हाई कोर्ट के लिए उसकी प्रेसिडेंट साहब नहीं करते तो वहाँ sunset clause है, unless such time the president make the rules.
So as I see it, the word law is evergreen in 191, and secondly, it might entail other instruments, but what I'm concerned with right now is the Act of the Parliament is also there.
So-
and that is enough for me to go forward.
Oh, yes, so
Are you going to answer my question? क्योंकि वो तो रह गया.
According to
I
you,
owe an answer to a lady.
according to you, once the rules have been framed, in exercise of constitutional jurisdiction that 191 confers, they are law. Number one. Number two, because of the language of 191, it is an exclusive power given to the Supreme Court rules.
Where does the
Subject to the Supreme Court may make framed rules.
Yes.
So the Supreme Court framed rules.
And subject to the law and the
So,
constitution.
what you're saying is, once this law has been made or framed by the Supreme Court, can a subsequent act of the Parliament trump it or modify it or render it redundant?
My lord, there is no fetter, there is no restriction under 191 on Parliament's power to make any amendments, barring one, which is that it should not in any way undermine independence of
वो तो
judiciary.
standard test
वो
लगेगा ना. all
extended
the
test है,
first-
उसके अलावा there is nothing in the language of 191.
अगर मैं आपकी बात समझ
So,
पाया हूँ,
if you invert the
Ladyship, my lord is not letting
Equation.
me answer the question. So.
if you invert the equation, the same thing can be done by the Parliament, the same thing can be done by the Supreme Court. Both can make the law as far as practice and procedure is concerned. So you say there is no fetter on the power of the Parliament to amend the rules that the Supreme Court makes.
Yes.
So if you invert the equation, then there is no fetter on the power of the Supreme Court to amend the law that the Parliament makes.
But then it's
Subject
subject to.
Subject to what?
Law.
Subject to law, तो law वही है ना, आप कह रहे हैं ये भी law है, वो भी law है.
No, no, no.
So then there is
नहीं,
an
नहीं,
interaction
नहीं.
of two laws.
The interaction.
Or a conflict of two laws.
There is, no, there can't be interaction to two laws. In that broader sense, Constitution also is a
Then-
positive law. We
so
can't
then-
possibly say
so
that.
then the parliament that makes law that you're saying subsequent.
Parliament is the lawgiver, my lord. Let's acknowledge it.
Hold on. It stands on a higher pedestal.
Parliament is the lawgiver.
ये बताइए
जो सेपरेशन के ऊपर जब बात करनी है, मैं वहां तक अगर पहुंचा तो यही बात करूंगा कि
Learned Attorney General, ये बताइए
अगर ये आपका आर्गुमेंट मान लिया जाए तो ये बता दें कि 191 का मकसद क्या था?
Learned Attorney General, ये बताइए, if under the obligation, under the convention, the Parliament makes a law that all jail appeals shall be fixed within 1 week from the day they are presented, will they not prevail over any of the rules made by the Supreme Court?
Yes.
And those rules will then be subject to this law.
yes, that's right, my lord.
Mr.
And
Attorney
independence
General,
of judiciary is not
And
affected.
independence of
Mr.
judiciary is
Attorney
not
General-
getting affected by this. Access of
Mr.
justice is
Attorney
being
General, if argument is accepted in toto, then what was the fund to insert this 191, Article 119 in the Constitution?
I didn't get the question, my lord.
My question is that what was the fund to insert 191 in the Constitution if it was not the intent of the legislator that the authority has been given to the Supreme Court to frame rules?
Yes, the authority has been given, but with a preface, with something which it is subject to, which is the Constitution
It
and the law.
doesn't mean anything. If it was
that's
exclusive
why
within the
the
domain of the
argument-
legislator, then this 191, that is of no use.
How, so I didn't, I still
What is
haven't
the
gotten
purpose of,
question.
what is the purpose of making these rules?
But-
To give effect to the Constitution and law.
And to have the court function, and of course, that's the purpose.
Because the Constitution and law is not so exhaustive. That's why rules are framed to give effect to the act and the Constitution.
May I answer the question first?
Your Ladyship, the term law as used in the Constitution, and as it has, you have noticed, it has been used at various instances. In addition to as an act of parliament, that term specifically act of parliament has been used. we will look at the provision, and from the provision we'll cull out what that term then implies, in the sense that, as I've submitted, which source of law is it referring to, or which source of law does it capture, whether it is exclusively, or, and the context of that provision be termed as an act of the appropriate legislature, or would it also include how the courts have expounded that law, and that law is also applied insofar as that proceeding is concerned. But for the purposes of Article 191, my respectful submission is that an act of parliament as law cannot be excluded.
But I accept your argument that it cannot be excluded. The question is that if it can't be just an act of parliament, it has to be something more. So when you argue on the strength that just look at it as an act of parliament, because it's included, it's enough to proceed forward and say, yahan se competence dekhte hain, that's where I have difficulty. That when it's just an act of parliament, then there is a definite word used that by an act of parliament. Here the word is law, so it will clearly mean more than just an act of parliament. Why are you reading it to the exclusion of everything else?
And Mr. Attorney General, I see it this way, that we are reading it as an exclusion to the other thing because the question is of competence.
Yes.
So I'm not concerned about the other instruments, I'm concerned about the main instrument, that's the act of the parliament.
So, and we'd be concerned perhaps with the other
clarification.
instrument, if I may just complete, with the other instrument, if there is any conflict between this instrument and some other principle which the court may have laid down, and I'll address that.
If I may have a clarification, if I understand you correctly, what you're saying is the rule-making power conferred on the Supreme Court by Article 191 is law, but the source of law in respect of the word used over there, that's the source of that law is not the rule-making power. That law, the source of that law, according to you, is an act of parliament. So that's the distinction that you draw, but you recognize, you accept that the rule-making power conferred by the Constitution on the Supreme Court also creates law. The source of that law, the rules, is the Supreme Court, but the source of the law, the word as used in the preceding part, the source of that law cannot be the rule-making power. It is somewhere else, wherever that may be, but it is somewhere. I have understood.
Yes, that's right. My Lord, if I may now address the second part of it, the second question, which my Lord...
Forgotten the second question. You've forgotten the second question.
No, I have the convention bit. The convention bit, because some interesting question had arisen.
That was question number 1. As according to me, question number 2 was relating to 56 rules.
Yeah.
56 rules have already... जी जी वो इस सारी conversation के अंदर back and
Now
forth.
you're back on, you're on the convention.
ये 56 के rules कौन से provision के तहत बने थे Constitution?
My Lord,
ये तो
56 के
President
rules
ने
तो
बनाए,
उस
the
वक्त third
President
schedule,
hereby make the following rules.
third schedule of 1956 Constitution उस वक्त बने थे सर.
हम नहीं मगर इसमें लिखा हुआ है rule making powers with the approval of the President.
जी जो 1956 के rules हैं. Because उस
और ये
वक्त
जो 1980 के या 191 के तहत
जी
बने।
191 के नीचे बने. उस वक्त 1956 के Constitution में approval required थी President की
जो
जो session.
लास्ट रूल्स बने हैं वो 80 में बने हैं ना
जी,
हमारे।
80 में।
तो इसका मतलब यह है कि legislator has not performed its duty for 43 years.
नहीं ड्यूटी नहीं परफॉर्म की, उन्होंने आपको कहा कि आप बनाते रहिए, ठीक बना रहे थे.
अब उनको ख्याल आ गया।
ठीक बने हुए थे तो उन्होंने कहा कि ठीक चलते रहे. अभी आके उन्होंने कहा कि कुछ थोड़ी सी इंटरवेंशन की जरूरत आ गई है.
मतलब आपका कहना है कि जब तक सुप्रीम कोर्ट सही चल रही थी तो उन्होंने
पहले तो फर्स्ट हियरिंग पे आपको कहा था कि अगर ये 70,000 पे पेंडेंसी चली गई तो शायद एक और लॉ की जरूरत पड़ जाए. अगर ये 20,000 पे आ जाए तो वो कहेंगे बैक ऑफ, पीपल विल नॉट अप्रूव ऑफ इट. हमने 5 साल बाद लोगों के पास जाना होता है, लोग हमें नहीं अप्रूव
लर्न काउंसिल जरा प्लीज आए ना अपने बिल को जरा देखें.
वो रिकॉर्ड लाए हैं आप, जो कितने लोग थे, कितनी देर इसकी बहस हुई, कितने लोगों ने
लॉर्ड वो रिकॉर्ड पे आ गई नहीं है, वो वेबसाइट पे भी थी, वो मैंने वैसे प्रोवाइड.
आप जब आप बात कर रहे हैं पार्लियामेंट की, तो पार्लियामेंट में एक बिल आया है. बिल के साथ स्टेटमेंट ऑफ ऑब्जेक्ट्स और रीजंस उन्होंने दी हैं. जो आप कह रहे हैं कि सुप्रीम कोर्ट में शॉर्ट कमिंग्स थी, लेट मी बी पोलाइट, शॉर्ट कमिंग्स थी, एक्सरसाइज ऑफ डिस्क्रेशन, एक्सरसाइज ऑफ जुरिस्डिक्शन, जिसके बेस पे आपने ये लॉ इंट्रोड्यूस किया. सो देयर इज अ स्टेटमेंट ऑफ ऑब्जेक्ट्स एंड रीजंस. जरा वो पढ़ लेंगे.
My lord, bear with me.
Statement नहीं है.
I'll read it for you. I'll read it for you. ये है, whereas the exercise of original jurisdiction of the Supreme Court under Clause 3 of Article 184 of the Constitution has been subject of discussion by various forums with respect to invoking suo motu power, constitution of benches, and the absence of right of appeal. And it goes on. Now come to Section 2 of the Act. यानी आपका जो ग्रीवियंस था, चलें हम कह देते हैं, लेट्स टेक इट, चलें ठीक है, वाज सुओ मोटो एंड 184(3) कि उसमें अपील नहीं थी, जुरिस्डिक्शन एक्सरसाइज हो रही थी. अब आप आए ये 2 को देखें, पढ़े जरा आपने जो एक्ट में लाए हैं, पढ़े.
Every cause, appeal or matter before the Supreme
यहाँ पे
Court.
रुक जाएं.
Yeah.
Why the overkill? Why? देखिए आपका जो कंसर्न था पार्लियामेंट के पास, चलें हम ये भी ग्रांट कर लेते हैं, पार्लियामेंट के पास पावर है, चेक्स एंड बैलेंसेस हैं, हम गलत कर रहे हैं, आप ठीक कर लें, तो आप वो चीज़ ठीक करें जिसका आपको ग्रीवेंस था. आपने तो पूरे सिस्टम आपने टच किया. वाई डिड यू, इफ यू लुक एट इट, देखें चीज़ों को एकदम से सारी की सारी चीज़ों को ऊपर नीचे करना, पॉलिसी वाइज भी गवर्नमेंट के लिए, पार्लियामेंट के लिए, उनका देखिए उनके पास पावर है, लेकिन उस पावर को आप कैसे एक्सरसाइज करते हैं वो भी आपने देखना होता है ना. एक पूरी इंस्टीट्यूशन है, इट्स अ फुल सुप्रीम कोर्ट, इट्स एन एस्टैब्लिशमेंट, इट्स अ टाइटैनिक, यू कांट जस्ट टर्न इट अराउंड के इस तरह करें. आप स्टार्ट करें, एक छोटी चीज़ दें, बोले चलें 184(3) को, और दूसरा है 186 जिसमें अपील नहीं है, रेफरेंस आ जाता है. आप उस पे स्टार्ट करें, देखें हम कैसे, हम नई चीज़ होएगी, स्लोली एंड ग्रेजुअली हम करेंगे. अगर ठीक नहीं चल रही फिर आप औरों के लिए, शायद हम खुद उन चीज़ों में आ जाएं. आप देखें आपने तो इवन एन एप्लीकेशन, कोई मिसलेनियस एप्लीकेशन भी आया, उसके लिए भी आपने 3 लोगों को कर दिया. तो थोड़ी ये पार्लियामेंट को भी देखना चाहिए. अगर गलतियां यहाँ पे भी हैं तो उधर भी देखना चाहिए कि जब आप चीज़ कर रहे हैं तो आप किस एक्सटेंट तक जाते हैं. ठीक. नाउ प्लीज कैरी ऑन विथ योर आर्ग्यूमेंट्स.
My lord's observation.
एजे साहब, अगर आप इसको इस तरह नजर में देखें कि रूल्स आर सब्जेक्ट टू द कॉन्स्टिट्यूशन एंड लॉ. जब 80 के रूल्स बने, लॉ नहीं था, और जब कॉन्स्टिट्यूशन में कहीं ये नहीं बताया कि हु विल कॉन्स्टिट्यूट द बेंचेस. तो ये क्या जरूरत महसूस हुई कि अब आपको याद आया कि कॉन्स्टिट्यूशन मेकिंग बॉडी होनी चाहिए, बेंचेस की कॉन्स्टिट्यूशन की कोई बॉडी होनी चाहिए, क्योंकि न तो कॉन्स्टिट्यूशन में था, न उससे पहले कोई लॉ था. रूल में तो हमने दे दिए, लेकिन रूल मस्ट बी सब्जेक्ट टू द कॉन्स्टिट्यूशन लॉ. क्या वो जो रूल्स में बताया गया कि चीफ जस्टिस कॉन्स्टिट्यूट करेंगे, ऐसी कोई प्रोविजन कॉन्स्टिट्यूशन में है गिविंग पावर चीफ जस्टिस और टू द सुप्रीम कोर्ट कि वो बेंचेस बनाने के इख्तियार किसी एक शख्स या फर्द वाहिद को दे?
Nothing on this matter in the Constitution.
आप
My
कहते
lord,
हैं
per
कि ये
se.
लॉ जब आया, नाउ सब्जेक्ट टू दिस लॉ बेंचेस इस तरह कॉन्स्टिट्यूट होंगे.
The Constitution does not obviously deal with the subject matter, at least to the extent of Section 3 and 4. Obviously, the Constitution does not provide any procedure in that sense. So, my lord, I'd just move on to now the question of whether the conventions, because there was a question that because of the convention, because the long-standing history behind the Chief Justice being masters of roster in the Indian subcontinent starting 1860 and so on, therefore it has the same status as that of constitutional provision as held in Malik Asad's case, and therefore this act was ultra vires. This is a submission which was made, and my Lord Justice Munib Akhtar also had
Can
an
I
observation
just
to that.
ask a question out of curiosity?
On this or something else?
Related to this, that there's a lot of emphasis on the rule-making power and the rules saying that the Chief Justice will constitute the benches, which necessitated the formation of this committee. So does that mean that the rest of the rules are all right and nobody has any issue with them? There's no need for any interference, there's no delay being caused because of those rules, There's no need for anything extra. Everything else is fine. It's just this one particular rule that is bothersome, and that is what is coming out of this discussion. Because as was mentioned yesterday, even to the extent of who will call a full court, it's not in the constitution, it's not in the rules, there's ambiguity, and there's been a lot of discussion about how a full court has not been called. Even you didn't think that that was also something necessary to regulate? I'm just trying to understand that where did this emanate out of? Only one issue has been highlighted in the entire set of rules.
Not just one. I mean, the non-fixation of applications where urgency is sought. I mean, it takes months at end. The matter doesn't get fixed. You know, I can tell you from my experience at the bar. I mean, we file applications for early hearing every month. And, you know, there have been instances I had pointed out, people in jail appeals, when they came up for hearing, people had already been executed. This court acknowledged it. So it is not that, you know, there is this act only addresses the question of master of roster. There are other aspects also.
The provisions of this act are mandatory or directory?
So it has a mandatory effect.
It has a mandatory effect. So if something that these rules, this act requires the Supreme Court to do, and for some reason it is not done, what is the consequence?
Consequence
may be considered at the relevant time.
that is one.
Please answer the question.
That is one. And two,
नहीं देखिए बहुत से कानून में ऑलरेडी एग्जिस्ट करता है, ठीक है. अब हम कोई एटीए का केस उठा के बाहर तो नहीं कहते हैं कि जी उनने एक मियाद लिखी हुई है कानून ने कि उधर जाएं, तो वो हमें हर चीज़ देखना होगी कि डायरेक्टली कॉन्सिक्वेंटली वो पर्टिकुलर केस कैसा है, हम जनरल ब्रॉड पैरामीटर्स कर दें. तो मेरे ख्याल में अगर इसमें मैं सिर्फ जो पॉइंट लास्ट डेट पे आपको कहा था उसमें अगर पार्लियामान चाहती तो एक कदम ज़्यादा जा सकती थी. वो कदम उन्होंने उठाया नहीं, और शायद इसलिए नहीं उठाया कि उनको हम पे एतबार है कि इसको हम खुद कैसे चलाएंगे. ये भी तो आप कह सकते हैं ना कि अब हम कहते हैं मैंडेटरी, आप लफ्ज़ इस्तेमाल कर रहे हैं मैंडेटरी, तो उसका कोई इसमें तो तस्करा ऐसा हो नहीं रहा है ना, उसमें कोई कॉन्सिक्वेंसेस दे रहे हैं. तो रूल्स ऑफ जितने इंटरप्रिटेशन है वो तो आपके ख़िलाफ़ जाते हैं. बट ये कह करके कि डायरेक्टरी और ये कानून का कोई मकसद ही नहीं है, ये भी शायद गलत हो. तो हमें देखें, एक इदारे को इदारे की इज़्ज़त करना चाहिए. यकीनन मेरे ख़्याल में पार्लियामान ने सुप्रीम कोर्ट की इज़्ज़त की और रखी कि भाई ये कानून तो हमने बना दिया है, मगर इसमें आपको उस तरह से मैंडेटरी में पाबंद नहीं किया है. अब आप की भी दानिश है, आप लोगों की अकल और सोच है, आप देखेंगे कैसे चलता है. हो सकता है इसके अलावा भी रूल्स बनाने की ज़रूरत पड़े. तो वो मेरे ख्याल में अगर हर चीज़ का हम आज ही जवाब दे दें तो कल हमारे पास केसेस आ जाएंगे, एक्चुअल केसेस, तो वो फिर तो हम पाबंद होंगे अपनी इंटरप्रिटेशन पे.
रूल्स के अंदर आपने ये एक्नॉलेज और रिकग्नाइज किया हुआ है. ऑर्डर 11 बिगिंस विद by saying save as otherwise provided by law. तो ये आपकी acknowledgement है full court की उन rules के अंदर कि अगर कानून कुछ कह रहा है तो आप उसको.
What's the response of the federation, official response of the federation? You are the chief law officer of the federation. To the question that I just asked. What's your official response to that?
My lord, if the Supreme Court chooses not to follow the law or not to bring its rule in line with the law,
will it not be a violation of the
We will pray.
violation of oath?
your oath actually requires you to act in accordance
Mr.
with the
Attorney
Constitution
General,
and the law.
Mr.
So I
Atta-
think we
Mr.
would
Attorney
be
General,
venturing into that territory
Mr. Attorney General,
which
please read to section 2, subsection 2.
of this act.
Yes.
Ji, sir. Soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure, including. Ji.
Procedure still has to be framed by the committee in view of the full court, because all matters are mentioned in section 2.
My lord, committee ने मेरी दानिश में
प्रोसीजर तो कमेटी ही बनाएगी ना.
कमेटी ने मेरी दानिश में
पहले बात सुन लें.
My lord, आप मेरी भी जरा सुनेंगे तो मैं जरा बात एक्सप्लेन कर सकूंगा. कमेटी ने मेरी दानिस्त में, क्योंकि सवाल मैंने समझ लिया था, कमेटी ने ये नहीं करना कि बाकी प्रोसीजर को टच करना है. कमेटी ने ये करना है कि हमने मिलना कब है, जुमे को मिलना है, हफ्ते को मिलना है, लिस्ट बनानी है, किस कैटेगरी के केसेस कहाँ जाने हैं. दिस इज टू माय माइंड व्हाट द
तो ये
कमेटी इज
रूल्स में भी यही कुछ है और क्या है रूल्स में? यही कुछ है.
रूल्स में तो ऐसा कुछ भी नहीं
बता
है.
दीजिएगा ये प्रोसीजर जो
रूल्स में
है,
तो ऐसा कुछ भी नहीं है.
दिस प्रोसीजर इज इन द कॉन्टेक्स्ट ऑफ द कमिटी और द सुप्रीम कोर्ट.
कमेटी सर,
कमेटी के अपने internal rules
कमेटी
हैं.
कमेटी ने फंक्शन करना है. इट्स मोर देन वन पीपल हु आर गोइंग टू मीट, सो दे वांट टू वर्क आउट देयर
Recovered to determine its
meetings, benches. So वो जो आपने
देखिए, we are expanding the scope of the challenge. The scope of the challenge is that this law is unconstitutional. Now we are going into how we will interpret, and I don't want to observe anything in the, whichever judgment is delivered, how, if the law is upheld, how it is to be. That is up to, at the time, appropriate body, whether it's a full court, whether it's a committee. We will certainly not accept or even consider what you say. We will determine that ourselves. Yes. So let's not go into uncharted waters. Simply an attack has been launched on the Act on its basis of its constitutionality, how it will work, whether it's functional, whether it's unworkable. It may require additional input from the committee or from the full court, are matters which I don't think we want to hear even from you, because we're not asking assistance. If a problem arises in a case, it may come, we may issue you notice under Order 27 to come and please assist us on that score. So let's restrict the scope of this thing. And I think the fundamental point जो हम लोग बार बार भूल जाते हैं, वो दुनिया जो है ना, वो एक दूसरे के साथ मिल चलती है, एंटेगनिस्टिक नहीं चलती है. ये जो पार्लियामान है हमारी दुश्मन नहीं है, और यकीनन पार्लियामान हमें नहीं समझती हम उनके दुश्मन हैं. तो दोनों को साथ भी हम चला सकते हैं कि नहीं मेरा इख्तियार और तुम्हारा इख्तियार. ये दुनिया चलती है ना, उनके बड़े बड़े इश्यूज़ हैं, क्लाइमेट चेंज हैं, लोगों के हकूक़ हैं. हम इस बारीकियों में फंस गए, क्या क्या हो रहा है दुनिया में, और दुनिया आगे जा रही है और हम लोग बस इस बाहर बहसों में पड़े हुए हैं. हम एक दूसरे की कदर, हम क्यों उनको मनफी तरीके से देखें. हम कह सकते हैं हाँ आपने कानून नेगेटिव इम्प्लीकेशन दें कि आपने गलत किया. भाई शुरू तो करें इस बात से कि आपने सही किया है. हाँ इसमें कोई गैर आईनी बात है वो हम देख लेंगे, उसको यहाँ तक ख़त्म कर दें. तो इतना हमें लड़ाने की कोशिश ना करें एक इदारे को दूसरे इदारे से. मैं तो कहता हूँ अंग्रेजी में पता नहीं उर्दू में कैसे कहेंगे, लिव एंड लेट लिव. और अब इसकी बस कॉन्स्टिट्यूशनैलिटी देखना है, बस इतनी सी बात है. अब हम वो इंटरप्रिटेशन हम लोग कैसे करेंगे, भाई हमारी मर्जी है. अब वो वक्त आएगा कर लेंगे इंटरप्रिटेशन. थोड़ी बहुत अकल समझ है, 40 साल से ज़्यादा वाबस्तगी है कानून से, कुछ ना कुछ समझ आ गई है, तो अब हर चीज़ हम लिख दें कि ये मसला आएगा तो हम यूँ करेंगे और ये मसला आएगा तो यूँ करेंगे, तो फिर तो ना कमेटी की अहमियत रही और ना वो फुल कोर्ट एडमिनिस्ट्रेटिव साइड पे उसकी अहमियत रही, क्योंकि अब फुल कोर्ट का जजमेंट आ जाएगा. फिर तो बिल्कुल आपने हमें पाबंद कर दिया और हमें स्ट्रेट जैकेट में डाल दिया. उधर हमें ना ले जाइए, आप सिर्फ फोकस रखिए आइन पे जो अटैक हुआ है.
My lord, grateful. My lord, now to constitutional conventions, if I may begin my submission on that. My lord, my respectful submission is that our constitution in its text does not recognize any convention. It does recognize customs or usages having force of law, but not the conventions. And I say this because conventions in historical sense, Article 8 Clause 2 and then Article 203B in Federal Sharia Codes is Clause C, which also uses the phrase customs or using having law. I'll come to that in due course. What are those customs or usages which have force of law? I refer to a statute of 1872. My lord, the conventions are a feature of an unwritten constitution, which is that of the United Kingdom. It is acknowledged by the English courts that the constitution, the conventions may be, the reasons for having those conventions, acting upon those conventions may be so strong that not acting upon them might elicit response from the people. But The conventions by themselves do not abridge the parliament's power to legislate to the contrary. And if so done, the courts cannot hold them unconstitutional. There are two judgments to the contrary what I am submitting. In Al Jihad Trust case, this court held that they do attain a status of law and are enforceable by the courts. And in Malik Asad, they go a step further and say that conventions established over a period of time have the same status as that of a constitutional provision. My lords, and with the benefit of addressing the full court, and those judgments not having the binding effect, if I may take your lordships to the critique of the two judgments by late Justice Fazil Karim in his book titled Judicial Review of Public Actions, Second Review, Volume 1. I'll place the copies before your lordship.
Judicial Review of
Actions.
What edition is this?
My lord, this is second edition.
I think he was one of the finest writers of Pakistan law. Each book is, I've always gained a lot from reading Justice Fazil Karim's books.
Volume and
Page 95. This is volume 1, my lord, page 95. I placed photocopies of the relevant pages. Page 95.
His skill was to explain complicated things simply. 95.
95 now towards the bottom, my lord. The last paragraph, but I'd start with the last, the second sentence. It was settled. Page 95, sir.
Last line.
Last line. 95, last line. It was settled in Federation of Pakistan versus United Sugar Mills Limited, PLD 1997, Supreme Court 397, that the expression law means positive law, that is to say, a formal pronouncement of the will of a competent lawgiver, and did not include what are mere legal precepts and theories. Next para. In sum, it appears to us that constitutional conventions are a special feature of the British unwritten constitution, and that they have no place in the written constitution of Pakistan. All the important parliamentary constitutional conventions have been written into the Constitution of Pakistan. Under that constitution, the courts recognize and enforce only what the law in the constitutional sense of the word is. Then, if we may say with great respect, Al Jihad Trust case, PLD 1996, Supreme Court 324, and Malik Asad Ali case were the product of a period of unfortunate tension between political organs and the judicial organ of the state of Pakistan. That period evokes painful memories, and it is better to forget it. Even the judges of the Supreme Court could not remain unaffected, so much so that at the time of Malik Asad Ali case, the Supreme Court itself was a divided house. In such a polarized setting, the venerable principle of the Committee of Judges is naturally the major casualty. In our humble opinion, therefore, the decisions in those cases should be confined to them only.
In curiam.
My lord. My lords, if my lords may kindly now turn to Article 8. And I'll just point out, walk you through the language of words, customs or usages.
Customs and usages of law have a totally different and distinct meaning.
Yes.
They've got nothing to do with constitutional law.
That's right.
They are recognized. Someone who has read, who can pick up any book of jurisprudence, and I can start with Samand on jurisprudence and go on. They explain what customs means. They explain what usages of law mean. They are absolutely clear cut that there is nothing to do
There is
with
this Punjab Laws Act 1872 actually, which the Punjab Laws Act 1872, which acknowledges.
What is that to do with constitutional conventions?
No, so I'm just concluding, making my submissions and moving on.
Usages of law are ordinary law.
I understand.
Constitutional conventions are part of constitution.
And that's what I am submitting, that what is or had to be acknowledged by the Constitution from customs or usages, the Constitution does so. Otherwise, as some genre of what exists, the Constitution does not say that conventions will be part of the constitution. The constitution actually incorporates them. So whatever, as Justice Fazil Karim just says, that the written constitution actually
But what about the
acknowledges them,
No, but
accepts
what
them,
about-
builds them into the
what
body.
Well, first of all, the fact that there are some constitutional conventions which are incorporated in the context of the constitution, that is premised that there are constitutional conventions. In fact, there are certain articles of the constitution which perhaps abrogate constitutional conventions. So when the constitution has to be read, it has to be read in the context of, it is premised on there being constitutional conventions, right?
Yes.
For example, in Westminster style democracy, parliamentary democracies, the head of state has what are called reserve powers. Those are constitutional conventions. They are recognized, they are recognized, for example, in Canada, where Canada has a written constitution. They are recognized in Australia, where Australia has a written constitution. They are recognized in India, where India has a written constitution.
And they are
So my
recognized by
point-
Pakistan, where we have a written constitution.
So my point is that if you're trying to equate customs and usages of law as used in Article 8, with all due respect, how can you do that when the constitutional conventions are on a different plane? And as you have very rightly pointed out, there are two judgments of this court now of some standing where the different view has been taken.
Let me just proceed a little further with my submission.
But are you saying that the word convention is not used in Article 8? And then are you fortifying your submissions by contending that Malik Asad case and the Al-Jihad case may be decisions of this court, but they do not bind this court in terms of Article 189, because it's very specific. The decisions of this court are binding on all other courts.
That's right.
And not on ourselves.
That's why I
Yes,
read
of
out-
course, they are weighty precedents. Doesn't mean we are shackled by them either.
That's why I read out the passage from Justice Fazil Karim's book. My respectful submission is that the Constitution.
Sorry to
Just
interrupt.
Karim Saab was the
just
judge
to
of the
conclude
Supreme
my
Court.
submission on this.
No,
Very
just one moment.
I haven't
sir.
said.
Just one moment. There is 189 deals with what is called vertical stare decisis. Also the concept of horizontal stare decisis. Now we are sitting as the full court, of course, but that doesn't mean that there is no such thing as horizontal stare decisis. Because if there is no such thing as horizontal stare decisis, then tomorrow a two-member bench will pick up whatever judgment or judgments come out of this full court and say, we are not bound by that.
No, this is not what I
This
said.
is,
This is exactly
I'm-
not
I'm-
what I
I'm
said.
addressing the
So I
learned
never
attorney
said it two-member bench is not by a larger bench.
three-member
So that
bench,
is absolutely not what I said. It will be a larger bench. But the larger bench is not shackled by, or the full court is certainly not shackled by precedent.
My lord, if I may now proceed. My respectful submission is that the Constitution never acknowledged Chief Justice as master of roster. Therefore, at any rate,
ये term पहली दुनिया में कहाँ इजाद हुआ ये?
my lord, in India,
नहीं, इंग्लिस्तान से हम लोग अंग्रेजी सीखते हैं ना, तो वहाँ ये इस्तेमाल होता है या नहीं होता है?
my lord,
मुझे नहीं पता ना, मैं आपसे वाकई सवाल पूछ रहा हूँ, जेन्युइन सवाल है। आपको पता है तो बताइए, नहीं पता है तो क्या नहीं पता है?
I'm not aware of when it was used for the first time.
हाँ,
The
किसी ने
first
तो
time,
इस्तेमाल
I'm
किया
not
होगा
aware
ना।
when it was used for the first time as a term of art. I mean,
नहीं, आई टर्म ऑफ आर्ट नहीं, कहीं इस्तेमाल हुआ कानून में इंग्लिस्तान के। भाई हम कहते हैं ना, हम इंस्पिरेशन वहाँ से अगर हम ले रहे हैं तो ये जरा मुझे पहले इसका जेनेसिस बताइए ना।
एक चीज का और
जैसे जमहूरियत का
बताना
जेनेसिस
चाह रहा
कुछ लोग कहते हैं मैग्ना कार्टा में है, तो चलें ये इस टर्म का जेनेसिस कहाँ है?
मैं एक चीज जरूर बताना चाह रहा हूँ यहाँ पे कि जब after the British assumed control of India after 1857, तो फिर यहाँ पे हाई कोर्ट्स बनानी शुरू की उन्होंने 1860 being the first year जब 3 हाई कोर्ट्स बन गई, and I looked up the data actually. Madras, Bombay, Calcutta 1862, Allahabad in 1866, and then Chief Court of Mysore in 1884. And the Federal Court India बनी वो ज़ाहिर है गवर्नमेंट ऑफ इंडिया एक्ट के बाद बन रही थी, तो 1937 में बनी. Out of these 6 courts, 1862
Lahore, there was
जी जी there were others, मैंने तो 6 का देखा है, 6 का
so many others.
there were several others. 1862 till 1947, out of these 6 courts, there were total of 62 chief justices. And my lords would be, I don't know, I was quite amused, well not amused, one could actually understand why. Out of these 62, 57 were British. And it made sense because they wanted to control every institution of the colony to actually make sure that they retain absolute control over them. And it is that power which was vested in the chief justices, the British chief justices, representing the crown in any rate, by race as well, and exercised by them, purpose being, in my respectful submission, to actually ensure that the courts are regulated.
आप मेरे सवाल का जवाब नहीं दे रहे हैं।
वो कौन सा सवाल है?
मास्टर ऑफ द ये किधर शुरू हुआ पहले?
ये मैं I'll have to go back and Google it. I couldn't find it.
इंग्लिस्तान में इस्तेमाल होता ही है,
I don't imagine.
अमेरिका में इस्तेमाल होता है, कहाँ इस्तेमाल होता है?
नहीं होता।
ये हमारी इजाद है, क्या है जरा बताएं तो ना।
ये
We brought it from our school days, you see, with the master, the schoolmaster.
but
मास्टर ऑफ द रोल्स तो मेरे ख्याल में इंग्लिस्तान में है, मगर मास्टर ऑफ द रोस्टर मुझे नहीं पता। मतलब इतने वकीलों ने बात की मगर किसी ने हमें इस बात पे जरा वजाहत नहीं की, मुझे नहीं पता इसका।
ये तो अब आप full court बैठिए, I'm sure you can find it out, but I'll look it up
homework
during
अपना
the
करें।
break if I can. But what my submission was that if at all it was a convention, this convention has to be disregarded because this convention is rooted in the colonial past. We must get it.
फिर अगर दूसरी
On
बात आ
that
जाती है ना,
ground, on
अगर
that
हम
basis.
कॉलोनियल पास को अपने सराह रहे हैं और अपने इस्लामिक पास को नज़रअंदाज कर दें, इस्लामिक पास में कोई मास्टर ऑफ द रोस्टर कॉन्सेप्ट रहा है? नहीं। मतलब फिर वो वाला सवाल उठेगा, और अगर नहीं है तो फिर हमें हमारी जो लाइट्स हैं वो तो हमारी लाइट्स तो कहीं और हैं ना, 1400 साल से पहले वहाँ हम देखते हैं। हम अपने कॉलोनियल मास्टर्स से तो ना सीखें ना, अदरवाइज फिर आज़ादी हासिल करने की भी कोई ज़रूरत नहीं थी। रहते चलता था निज़ाम, उस वक्त भी चल ही रहा था, लोग खा रहे थे, पी रहे थे, जिंदा रहे थे, तो फिर आज़ादी की भी क्या ज़रूरत होती? तो ज़रा ये आप लोग बिल्कुल छोड़ देते हैं। कोई इस्लाम पे बहुत हल्की बातें हुई, ज़्यादा नहीं हुई, इसके बावजूद के आइन में कई जगह तस्करा है उसका। शुरू ही होता है सेक्रेट ट्रस्ट। अब सेक्रेट ट्रस्ट में तो मेरे ख्याल में सेक्रेट जो बात कर लें अमानत की बात, तो मास्टर का कॉन्सेप्ट क्या वो डिस्ट्रक्टिव नहीं है? मास्टर तो एक ही है, ऊपर वाला।
My lord.
पता नहीं, आप बताएं।
My lord, I had submitted on the first hearing as well that what the parliament surely hasn't done is it has not arrogated this power of constituting the benches either to itself or nor has it conferred it upon any element or individual outside of the judicial
Who
branch.
is now under this act, assuming that it is constitutional, who is now the master of the roster? The
There are
committee?
masters, co-masters of
The
roster.
masters of the roster. Or let's use the collectivity as in a
Master
singular
and
noun.
co-masters, sir.
But the question still remains: who is the master of the roster? The committee.
So,
Right? They do exactly what the chief justice.
so let me
has
just
been doing.
rephrase it.
Whether you like this phrase "master of the
let me
roster"
उसको
or
करना है
not,
address.
I am using it to express in shorthand the concept of what it is that Section 2 of this
My
Act
lord,
chooses to do.
My lord, what
In that sense, who is the master of the roster? 3 judges.
you've done away with master of roster
Arey,
concept.
3 judges na.
No,
committee.
it's a collegium now.
जी?
It's a collegium now.
अब ये भी तो
You've
जवाब
done away with the
आप ये
concept
भी
of
तो जवाब दें कि
आप
कोई नहीं
already
है।
collegium,
हाँ?
इतने जज्बाती होने की जरूरत
नहीं,
नहीं
मैं तो वैसी बात कर रहा हूँ, जज्बाती तो मैं होता ही नहीं से।
आप जज्बाती ना हो.
नहीं,
Let's call it a committee. But the committee.
It was just a statement
अरे,
made of
3-member
the
committee जज्बाती नहीं. देखिए ये भी एक सोचने की बात है कि 1947 के बाद से हमारे पास 56 का आइन आया, 62 का आइन आया, 73 का आइन आया, interim constitution आई. Consciously, deliberately, the people of Pakistan expressed a will to follow models that were existing, that go back to the Government of India Act, colonial, that go back, if you go further back in history, to the British North America Act of 1867, Canadian Constitution, colonial. So 4 times or 3 times the people of Pakistan have made, I exclude the 1962 Constitution because that was a,
Not colonial.
no, because
In a
that-
different way.
No, because that said, now therefore I, Field Marshal Muhammad Ayub Khan, give to the people of Pakistan this constitution. 56 constitution and 73 constitution don't say that. They said, we the people give this constitution to ourselves. That's the reason. So let's not go into what is colonial and what is not colonial and remain focused over here. A collegium, committee, whatever you want to call it, of 3 judges now controls all the affairs. Okay? You say that is good, that is progress. I put it to you, well, why not the full court? Put it in the hands of the full court. Why should, for example, if one judge, if I don't agree with that, by the way, what I'm about to say, but if one view is that 15 minus 1 is 14. 14 judges are in thrall of the Chief Justice. Now 15 minus 3, 12. 12 judges are in thrall of 3 judges. If the committee is 5 judges, 10 judges are in thrall of. अरे भाई फिर कर देना फुल कोर्ट जो चीज हमारे रूल मेकिंग पावर की प्रैक्टिस और कन्वेंशन है फुल कोर्ट ही करेगी ठीक है अगर पहलों ने नहीं किया चले अब कर दें अगर किसी को शिकायत है कि जी पिछलों ने नहीं किया चले अब कर दें किसने रोका आपके कानून ने रोका है आपके कानून ने मुसल्लत किया है विद ऑल ड्यू रिस्पेक्ट टू हुएवर द बिकॉज जजेस कम एंड जजेस गो whoever is for the time being member of that collegium or committee आप देखिए आप जो बातें कर रहे हैं ना आप उसकी विद ऑल ड्यू रिस्पेक्ट और ये मेरी आपसे मुअद्दबाना गुजारिश भी है और एक क्वेश्चन भी है आप फिर उसी को अंडरमाइन कर देते हैं कह के कि जी 1 मैन मैं आगे अगला लफ्ज नहीं इस्तेमाल करूंगा तो 3 मैन और पर्सन आई एम सॉरी टू द जजेस सिटिंग ओवर हियर और 5 पर तो मैं खत्म कर देना भाई हम खुद कहते हैं भाई हमारा फुल कोर्ट करती है ये काम प्रैक्टिस और प्रोसीजर सुप्रीम कोर्ट का कहते हैं आपने अब हमें जकड़ दिया और आप कहते हैं जी दिस इज प्रोग्रेस
हमें तो पता नहीं था कि आप
देखिए अटॉर्नी जनरल साहब आप ये प्रोग्रेस है या नहीं है हमारे सामने तो सिर्फ आईनी सवाल है जो जज साहब ने भी पूछा हुआ है कि बस मेरे हिसाब से तो एक ही सवाल बनता है कि ये कानून आईनी है नहीं अच्छा है बुरा है उस पर भी तबसरे हो सकते हैं बहुत सारी राय दी गई हैं कोई समझते नहीं अच्छा है कोई समझता अच्छा है चलिए ठीक है उससे फ़र्क फिर भी नहीं पड़ेगा ये कानून बरकरार नहीं रह सकता है अगर ये आईनी नहीं है ख़त्म और चाहे कानून जो भी अच्छा हो बुरा हो फिर भी बरकरार रहेगा अगर आईनी है तो बात तो वहीं आके ठहरती है मगर अगर वजूहात पे जब जाते हैं ना कि क्यों किया तो क्यों किया में तो फिर बहुत सारी वजूहात हैं और वो जहाँ तक बताई गई हैं और मेरी ज़ाती राय में एक अच्छी वजूहात दी गई हैं अब उनकी नीयत क्या थी नीयत तो कोई नहीं देखता है ना वो तो ऊपर वालों की नीयतों में आप नहीं जाते हो ना वो लोगों ने कलमे पढ़े जब उनका गर्दन तलवार के नीचे थी तो मगर फिर भी उन्हें पढ़ लिया तो बात ख़त्म हो गई थी तो अब हम उधर नियतें क्यों जा रहे हैं हम सीधा आईनी बात है छोटी सी बात है इसका इतना हमने लंबा इसको खींच रहे हैं अच्छा है बुरा है ऐसा है किया वैसा किया है तो और दूसरी बात है कि आप एक दूसरे को लड़वाएं तो नहीं आप एक इंस्टीट्यूशन को दूसरे से भी हम उस इंस्टीट्यूशन की कदर करते हैं और हम चाहते हैं कि वो हमारी कदर करें और जहाँ तक कोशिश करें एक दूसरे वो हमारे कानून जो बनाए हम उनको सराहें जहाँ तक मुमकिन है और वो हमारे फैसलों पे अमल करें इतनी सी बात है
Entry 55 अब I think अब separation and independence we move on to entry 55
आगे बढ़े असल क्वेश्चन पे आगे एड्रेस करें
You see, as the Honorable Chief Justice said, there is one question. Actually, I had posed 2 questions. The stages, well, they are the stages of the same question. The first question was, you have to show that the Parliament is competent. So there is a question of competency. But the probe doesn't end there. Even if the Parliament is competent, some provision of the law is in conflict with the Constitution, it can still be struck down. So
I stand corrected. I stand corrected. 2 questions there. ठीक है.
You would not only have to answer the question of competence, you would also have to take us to each provision and justify that it is not in conflict with any provision of the Constitution. So keep that in mind and please proceed.
My lord, with laws, I thought their constitution is assumed. The party shows that this provision is unconstitutional, and then I defend that provision. It seems so that all of the provisions have so far.
You're saying the burden is on the person challenging it, and the burden does not lie on you to justify it.
Yes, and then if the burden
But
is
since the
discharged,
question has
obviously
been
it's
posed, so
shifted.
you can see.
And I'm assuming from this question,
So you
that
can
at least
answer
in
it.
my lord's estimation, that burden
I
stands
assume
discharged.
I assume you're not going to rest your case by saying they failed to discharge the burden.
My lords, now with this question, I actually wanted to move to entry 55, but this question
Yeah,
is something I'll
but
come
it's
back
okay.
to. I'll then come back to it
that.
because
Please
appeal ki
take,
baat hogi.
go at your
My
own
lord,
pace and according to your own
if my lords, if I may take your lordships to entry 55 now, and my reading of entry 55.
अच्छा पहले ये वजाहत कर दें क्योंकि एक राय है कि 55 है, दूसरा है 58 है, दूसरा है तीसरी राय है कि 58 है मगर 58 ना भी है तो 55 फिर भी है, तो आप कोई आपका क्या स्टैंड है?
मेरी राय में as far as section 5 is concerned, it is rooted in entry 55, and the other provisions are to be construed under Article 142A, read with 58, and then back to 191.
So what?
As far as entry 55 is concerned, it may be read with 175 clause 2 and entry 55.
What was
read
very
with 142A.
aptly put by your predecessor in the line of arguments, Mr. Faisal Siddiqui, that it's a ping-pong effect. It goes from 58 to 191. Back to Article
58 is a
142.
gateway. I mean, 142, where everything starts, takes you to the list. 58 brings you back to the Constitution. 1 through 57 keep you there. So that is how I see. I see how the Constitution is functioning. So entry 55, my lords. Now, there's two parts, but I read these two parts somewhat differently than how my predecessor had read out. I'd read it first, toto, and then I'd submit how I read it, and then make my submissions. Jurisdiction and powers of all courts, except the Supreme Court, with respect to any of the matters in this list, and to such extent as is expressly authorized by or under the Constitution. I'll take a pause here. And the enlargement of the jurisdiction of the Supreme Court and the conferring thereon of supplemental powers. My lord, my reading of entry 55 is that the last two parts, the enlargement of the jurisdiction of the Supreme Court and the conferring thereon of supplemental powers, have to be read with the exception, except the Supreme Court. And insofar as jurisdiction and power of all courts are concerned, I read it, jurisdiction and power of all courts with respect to any matters in this list and to such extent as is expressly authorized by or under the Constitution. So this term, to such extent as is expressly authorized by or under the Constitution, is in relation to all courts except the Supreme Court.
So you're saying the
For the purposes
enlargement of jurisdiction
is for
should
the
not be
Supreme
read
Court.
with expressly authorized by or under the Constitution?
Yes.
I didn't get this point. I didn't get this point.
What you're saying is, as far as the Supreme Court is concerned, the enlargement can only be done where there is specific authorization.
No,
You're
sir.
saying otherwise.
I'm saying otherwise.
You're saying for the Supreme Court, you don't need any express authorization. It is
For the Supreme Court, there can only be enlargement, and we have to go to the language, and there is no such thing as far as
express authorization की जरूरत नहीं है.
So Supreme Court के लिए ये apply नहीं करेगा, High Courts के लिए करेगा, वो इसलिए करेगा because High Courts में there are not just High Courts, all courts, because there are three sorts of courts which are dealt with under the by
No,
the
but
Constitution.
you are saying to read jurisdiction and powers of all courts to such extent as expressly authorized by or under the Constitution.
With respect to any-
Yes, so you're saying read the jurisdiction and powers of all courts with expressly authorized by the
So
Constitution.
let me just.
Where is it expressly authorized by the
जी वो मैं उस पे
Constitution?
आऊंगा. I would read with respect to any of the matters in this list and this is in conjunction with, to such extent as is expressly authorized by or under the Constitution, and then the comma is separating what is to be done in so far as Supreme
So there's no restriction on enlargement of jurisdiction, as you read.
of the Supreme Court.
Then what happens to expressly authorized by, I'm not.
My Lord, this in my respectful submission, this is something which relates to the high courts, administrative courts and federal Sharia court.
Okay,
Why
so
then-
you
why-
mean the
High-
bar is lower for the Supreme Court and
Though
higher
there is a
for
reason,
the other
though there
courts?
is a reason, because as far as jurisdiction and power of all courts are concerned, it can be done through statute, but only to such extent as is expressly authorized by or under the Constitution.
No, but then.
And in
That-
relation to the matters in
that
this
can be-
list.
Because that can be curtailed.
Yes.
But in case of the Supreme Court, its
It can't be
jurisdiction
curtailed
cannot be
and it can't be curtailed.
interfered.
And if let me just walk you through Article 199 and then 212 and that's just.
Let me read this entry 55, just to make sure I have understood, because I'm sorry, I'm still having some difficulty here. So as you read it, jurisdiction and powers of all courts, except the Supreme Court, with respect to any of the matters listed in this court,
And
to such extent as is or expressly authorized by or under the
yes,
Constitution.
so the and used after, and used this-
And the
No, there is no
enlargement, the enlargement of the jurisdiction of the Supreme Court and the conferring thereon on supplemental powers. That you say is separate from this.
So as Justice Attar just pointed out, you're saying that it actually turns on the word enlargement because there's a specific thing that a power could be given, that is enlargement. So we don't need to worry about any extent or anything because it's merely
So
bestowing,
Supreme Court-
enlarging, it's not reducing,
your-
it's not altering, it's enlarging. So that's as simple as that.
So
It
as
doesn't have the,
Your reading eliminates the word and surely
and from.
from the text.
So there are two ands here. One is
So
after
first
the
one-
list,
No, the first one.
the and, yes.
Jurisdiction and, sorry, the first one is jurisdiction and powers of all courts
With
except
respect
the
to any
Supreme
of the
Court,
matters in the list
whether any
and,
of the matters of the list,
and,
नहीं, अगर आप अब आगे जो चीज आ रही है पीछे से जोड़ रहे हैं तो ये and तो फिर eliminate हो गया
and के साथ वो conjunctive हो रहा है ना sir?
and नहीं
In conjunction हो रहा है ना? And to such extent as is
And is
expressly authorized by or under the
and
Constitution.
की तो and की
It
तो
makes it disjunctive.
and की तो जरूरत ही नहीं रहती ना
My lord,
अगर इतना पढ़े jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list to such extent as is expressly authorized by or under the Constitution. Is there any grammatical problem with this? Is there any grammatical problem?
no, it would have
No.
been fine, yes.
So therefore, on your reading, and is eliminated.
No,
And becomes redundant. And makes sense only if it creates the break and then relates such extent as expressly authorized by under the Constitution to what is following. आप समझ रहे हैं ना?
what is following
अरे
after,
अगर आप and की जरूरत नहीं रहती ना आपकी रीडिंग पे.
no, and की जरूरत देखें, अब यहाँ
मैं
पे,
दोबारा पढ़ता हूँ, चलिए दोबारा पढ़ते हैं.
on that count, my lord, and जो है उसके बाद
दोबारा
second
पढ़ते हैं ना,
sentence.
दोबारा पढ़ते
Attorney
हैं.
General,
क्योंकि
Learned Attorney
by
General,
और अंडर के
ये मैं इसकी आपको कॉन्स्टिट्यूशन में भी लेके जाऊंगा to
Jurisdiction-
make sense of it.
Jurisdiction
Attorney
and
General.
powers of all courts except the Supreme Court with respect to any of the matters listed in this, any of the matters in this list, to such extent as is expressly authorized by or under the Constitution. Full stop. Is there any error, any grammatical error in this sentence?
No, it could be read as
Therefore, and becomes
and
redundant.
that is,
भाई, मैंने full stop भी डाल दिया, just to clarify.
there is a reason, there is a reason. अब मैं इसको
and किधर गया?
इसको जरा करेंगे ना, समझेंगे इस तरह से कि there are two jurisdiction जो courts पे grant हो रही है. One is with respect to the matters in the list. And we have to go to the Constitution, what the Constitution, the body of the Constitution is doing. And for that, if my lord may kindly turn to Article 212, for example. Let's go to 212, let's go to 199. Let's go to 199 first and then see what is the authorization, the extent of authorization as far as high courts is concerned.
उसमें तो जरूरत ही नहीं ना रहती.
नहीं है जरूरत है.
क्या जरूरत है?
Clause 5 देखेंगे उसमें. Clause 5 of Article 195, 199,
ये-
which
ये
says
आप क्या-
the
आप-
extent to Article 199 applies, and there is carve out.
Mr.
The
Attorney
definition
General,
of-
I mean, before, I mean, looking at 55, I mean, we might lose ourselves in the grammar of it, but larger than that is perhaps the word enlargement.
Yes.
And what is actually happening? You're enlarging the jurisdiction of the Supreme Court. It requires no extent because it is a positive thing that you're just adding to the Supreme Court's jurisdiction. So वो उसके साथ पढ़ना मतलब उसके कोई
मेरे रिस्पेक्टफुल सबमिशन है कि नहीं पढ़ना होगा बिकॉज वो फिर काउंटर इंटुइटिव है. वो इसलिए भी काउंटर इंटुइटिव है कि देयर इज नथिंग इन 184, 185 में क्लॉज 2D है which says that through an act of parliament आप उसको ऊपर ले जाएं उस अमाउंट को या रिव्यू के अंदर.
आप इसको आप इस तरह दोबारा मैं
तो इसलिए there is nothing जो प्रोवाइड कर रहा है कि एक्सटेंट क्या है, whereas in the case of high courts for example there is an extent which is provided. For the administrative tribunals also there is an extent which is
Jurisdiction and
provided.
powers of all courts except the Supreme Court with respect to any of the matters in this list and to such extent as is expressly authorized by or under the Constitution. Full stop. आप इस तरह पढ़ रहे हैं उसको?
मैं इसको जी हाँ.
इसमें
Constitution के बाद comma लगा हुआ है ना,
surely
the
on
enlargement.
this, grammatically speaking for myself, there is an expectation कि इसके बाद भी कुछ आएगा. अगर and हो ना, तो उसके बाद एक expectation है and to such extent as is expressly authorized by or under the Constitution. Full stop creates a vacuum because there is an expectation to such extent as is expressly authorized by or under the Constitution. What?
Yes. So you
लेकिन तो आपका and जो है ना,
इसको एक सेकंड के लिए
तो
इसको
बात तो
read
सुनिए।
differently.
अब मैं आपकी बात समझने की कोशिश कर रहा
मैं आपको समझाने की
हूँ and में ये प्रॉब्लम है. अगर and इस तरह से रखते हैं ना, and निकाल दें तो कोई प्रॉब्लम नहीं है.
इसको जरा इस तरह से पढ़े. and की निकालने की जरूरत and क्यों जरूरत है and को रखना. So let's just read it again. Jurisdiction and power of all courts with respect to any of the matters in this list. Let's take a pause here. All courts, matters in the list. And then, and to such extent as is expressly authorized by or under the Constitution. Full stop. So, my submission is that this language and the express authorization is necessary because 199 applies the constitutional jurisdiction of high courts in terms of territory, of course, but then there is a carve out, the persons to whom this jurisdiction can be applied. And then 212, Article 212. with respect
Do we
to
need
administrative courts.
a professor, do we need to make amicus a professor of the English language, Mr. General?
My lord, I
think we can understand it, whatever we understand it to mean. And can I just ask you a related question? Does the Supreme Court have power to enlarge its own jurisdiction? Yes or no?
No.
You are saying that Parliament, their side is Parliament can only do so through constitutional amendment. Now, I don't know why you are skirting the issue.
No. It is required to or is bound to act in accordance with the.
It cannot
what the
enlarge its
Constitution is.
jurisdiction, correct?
Yes.
How has the Supreme Court enlarged its jurisdiction in cases decided by three-member benches, by adding on benches, and which jurisdiction was assumed then? There have been recent examples of the Supreme Court creating, enlarging jurisdiction, but creating jurisdiction not envisaged in the Constitution. But those are sensitive matters, so you won't talk about them,
I
correct?
want to talk something
Correct?
about it. I know, I want to talk something about it. And let me just talk about it. And then,
जवाब तो दे देना before you field another question. You can't field 5 questions simultaneously. You have to finish one.
so I have to field this question and then I'll come back.
Nando, why did they use the word expressly? अगर expressly नहीं भी होता, by और under का यानी इसका मतलब हुआ कि by के लिए भी express होना चाहिए.
So, वो
देखिए,
इसलिए-
by in itself is always express.
वो मेरा इसलिए there are two there. One is where the Constitution now, when the term by is used, the enactment in this case, the Constitution directly provides for what can and cannot be done. And under is where an additional act is required in an
मैं
act of
आपसे एक
parliament.
सवाल इससे आगे जा रहा हूँ. मैं ये कह रहा हूँ चले. बाय का मतलब है कॉन्स्टिट्यूशन देर है और है कि उसमें आप देखें अकस करें अगर मिलता है. Why did they say expressly? मतलब कि बाय के लिए भी हमेशा express by in itself is always express.
So, uski reason, jo, at least to my understanding, is because the Parliament has the power to determine jurisdiction and power of all courts, other than the Supreme Court. So, it was necessary that the Constitution states so. To what extent, with respect to what is already dealt with in the body of the Constitution, you can and cannot do. Because otherwise, when the Parliament legislates with respect to all courts, for example, Article 212 deals with administrative courts and tribunals. Okay. Under Clause 1, subclauses A, B, C state what can be done under these tribunals. And then Clause 2 says no court shall otherwise grant injunctions, that and the other. So this is the clause, this is the extent of authorization under A, B, C. And this too then prevents Parliament from using its power under Entry 51, jurisdiction and power of all courts, from conferring this power on the all
And
other
you're saying
courts.
this is, in the natural flow, is to be read with the upper
Yes,
portion?
that's my
So
suggestion.
what is meant by the term enlargement? And if it was, is it just enlargement
मैं
means
उस पे जी बिल्कुल अब ये
या
next
enlargement and
argument ये है।
conferment या creation
ये
of
next argument
jurisdiction में
अब
फिर
Learned Attorney
आपके
General.
मुताबिक वो सुप्रीम कोर्ट को लगता ही नहीं एनलार्जमेंट वाला जो पोर्ट है
वो लगता है ना जी
अच्छा हाँ सॉरी ओके
enlargement तो लिखा ही सुप्रीम कोर्ट
Expressly authorized, ठीक।
yes
Learned,
express
Learned Attorney General, what is the constitutional principle? If there can be two interpretations, which interpretation should be adopted?
one which
Because in
favors
this
the
particular
constitutionality
case,
of the
the
statute.
express authorization is required. The jurisdiction or power can be curtailed, but where it is enlarged, as my brother Justice Mansoor has stated, that should be welcomed by this court. It is
And-
being enlarged.
And my lord, in continuation of my previous submission, because there is no express authorization required, then what my lords now have to see is whether there is any prohibition in 184 or 185 from extending, enlarging 185 to apply to orders and judgments under 184. So if there is no prohibition, then you are not drawing that authorization from the language of 184-85. You are drawing that authorization from Entry 55, where it permits the Parliament to enlarge the jurisdiction, the existing jurisdiction.
And
of the Supreme Court.
185 2D sort of blends with actually, where they
Yes.
talk about, it just goes with it.
Absolutely.
185 2D
Yes.
flows with this.
It does,
enlargement.
it does. And then, my lord, one aspect, I intended to make this submission a little later, but I need to now just place some facts before your lordships.
ये आपने enlargement और conferment
यही अभी बात है। Enlargement, if you disengage, you read the entry as I have just submitted, and there is no requirement of the extent of express authorization by or under the Constitution as far as the Supreme Court is concerned, then the latter part of this
And that
entry,
is-
the enlargement,
आप जो बात कर रहे हैं, then that becomes the equivalent of what was, I think, Article 188 of the interim constitution. वो जरा पढ़िए।
additional jurisdiction, which is
अरे बात सुनिए, ये आर्टिकल शायद 1962
की
कॉन्स्टिट्यूशन
एक रीजन थी मेरे हिसाब से। मैं आपको वो जरा एक्सप्लेन करना चाहता
मेरा
हूँ।
सवाल तो सुन ले।
वो सवाल, लेकिन वो सवाल जो है
लेकिन आप
crystallize हो जाएगा अगर आप वो सुनेंगे।
सवाल तो सुन ले। आपके मुताबिक देन वो जो the fact कि 73 कॉन्स्टिट्यूशन में आर्टिकल 188 has not been carried into the 73 constitution becomes irrelevant.
उसकी एक रीजन है जो मुझे समझ में आती है, एंड वो डिस्टिंक्शन थी 56 की और 72 के इंटरिम की। नाउ 56 कॉन्स्टिट्यूशन, there was Article 22 which was similar to Article 32 of Indian Constitution, conferring, giving right to writ, similar to what we have under 199, वो दे रहा था सर, और complete in totality दे रहा था।
वो तो आप बात कर रहे हैं जो which is equivalent or of 184(3).
184(3) सर जो 1956 का कॉन्स्टिट्यूशन है,
Right to
उसमें जो
move the court for enforcement of any rights under this part is itself guaranteed.
is not just guaranteed. 56 actually said that the Supreme Court shall issue these writs, this, that, and the other, identical to, nearly identical to Article 32 of India. Now, Article 7, Clause 4 of the interim constitution says that the right to approach the Supreme Court for enforcement of these rights shall be guaranteed.
चलिए वो मैं उसकी बात नहीं कर
मैं
रहा हूँ,
उस पे
मैं तो
आ रहा हूँ,
आपकी
मैं-
enlargement of jurisdiction
मैं वो
की बात कर रहा हूँ।
188 को जरा एक्सप्लेन करके फिर उस पे आ रहा हूँ कि why 188 was necessary according to me. Because Article 7 Clause 4 simply said that the right shall be guaranteed. Now it did not provide for the enforcement mechanism, unlike the 1956 Constitution, and the article was 156. So therefore, perhaps to enforce this Clause 4,
Can't we
additional
read the,
jurisdiction
can't
could
we
be
read the
granted.
language of 188? Such other jurisdiction as may be conferred by law.
Yes.
Other, not the jurisdiction already conferred by the
So
Constitution.
the already conferred jurisdiction was 184, equivalent to 184.1.
भाई, वो तो supplemental powers की बात हो गई ना, ये other jurisdiction है ना। देखिए आप जिस तरह इसको पढ़ रहे हैं without, जो मुझे बात जो बात bother कर रही है ना, वो ये है कि जो चीज as close to the 1973 Constitution as the interim Constitution जो उसमें थी, जिस structurally जिसका relationship of legislature with the Supreme Court was the closest, and both of them went back to the 1935 Act. उसमें अगर वो आर्टिकल की जरूरत पड़ी आपकी इंटरप्रिटेशन पे तो वो इररेलेवेंट हो जाता है, भले वो आर्टिकल 188 हो या ना हो, भाई इन्लार्जमेंट में तो कुछ भी हो सकता है। नहीं,
No. Why? Because under the 1956 Constitution, Supreme Court had original jurisdiction akin to Article 184, Clause 1.
नहीं, मैं इंटरिम की बात कर रहा हूँ।
जी, well, sorry, मैं interim Constitution, not 56. Interim Constitution, maybe the Supreme Court had 184.1, equivalent of 184.1, barring Article 7, Clause 4, which guaranteed the right but did not include it under 180. The article was 185. The parameteria of 184, how that right would be exercised, etc. And then it had the appellate revisional review and
नहीं, फिर आप 188 को of interim constitution को पढ़ रहे हैं as essentially conferring only supplemental powers.
what I
क्योंकि आप देखिए ना, फिर जो equivalent entry थी 55 आपके मुताबिक, तो फिर उसको भी इसी तरह पढ़ना चाहिए,
नहीं, अब
नहीं
उसमें
पढ़ना चाहिए।
जी, उसमें the reason why
wording फर्क है या identical है?
the wording of the entries
Same as same.
जी same है, interim की तो
It's
same.
exactly the same.
हाँ।
If
अगर
it-
आपके मुताबिक वो should be read the same way.
Mr. Attorney General, if I could just jump into this
नहीं,
discussion.
before you jump into discussions, आप लगता है मैंने जो सवाल पे आप बिल्कुल आपको पसंद नहीं है।
Sir, वो
नहीं, देखिए ये मुनासिब बात नहीं है ना।
I'm sorry, मैं
हम देखें ऐसे देखें, ऐसे नहीं हो सकता है ना। हम एक और आईनी इदारे की इख्तियारात पे मीन मेख निकाल रहे हैं, और जब हम खुद ऐसे इख्तियारात इस्तेमाल कर रहे हैं जिसका वजूद ही नहीं होता है, इस्तेमाल हुआ है या नहीं हुआ है,
हुआ सर।
तो फिर
मैं
वो
सिर्फ
आपको
कुछ
तो
आपको
सवाल
बताना
पूछना
चाहता
चाहिए
हूं,
कि आप हमें भी बता देना कि आप कैसे इख्तियार इस्तेमाल कर रहे हैं। वहाँ तो इतना भी हो सकता है, इन्लार्जमेंट क्रिएशन है, क्रिएशन इन्लार्जमेंट है, इतनी बारीकियों में जा रहे हैं। यहाँ तो सिरे ही से उस कोई है ही नहीं पावर, मगर फिर भी कर लिया। मगर क्योंकि आप नहीं कहेंगे, क्योंकि आपको रोजाना सुप्रीम कोर्ट के सामने आना पड़ता है।
नहीं सर, मैं तो
नहीं, ये मुनासिब बात नहीं है। आप फिर देखिए,
Since
आप जवाब नहीं देना
1973
चाहें, आप ना दें जवाब।
Since 1973, as far as the numbers I could
सिर्फ 73 की बात नहीं हो, ये मौजूदा हाल की बात
मैं
हो रही
अब
है।
आपको भी बताने लगा हूँ सर।
हाँ।
2023 in last 50 years and there could be a
देखिए, अगर इतनी
margin of
बारीकियों में
error.
जा रहे हैं ना, फिर हमें अपने सबसे पहले अपने ऊपर उंगलियां उठाना चाहिए।
232 सुमोटो लिए गए जो मेरे पास
सुमोटो की बात नहीं हो रही है।
मैं अभी उस पे
नहीं, मैं सुमोटो की बात ही नहीं कर रहा हूँ।
मैं 184.3 and
नहीं
all of that
नहीं
मैं उसकी
नहीं,
तरफ आ
मैं
रहा
उसकी बात बिल्कुल नहीं कर रहा हूँ। मैं ये कह रहा हूँ, एक बेंच ने फैसला किया, ठीक है ना, रिव्यू का जुरिस्डिक्शन हमें समझ आता है, और लोगों का सिंबल, जज जिसको सिंबल कर लिया गया, और वो फैसले को निगेट कर दिया गया। मेरे हिसाब से ये ना रिव्यू जुरिस्डिक्शन है, ना ओरिजिनल जुरिस्डिक्शन है, ना अपीलेट जुरिस्डिक्शन है, ना ट्रांसफर जुरिस्डिक्शन है, ना कोई जुरिस्डिक्शन है। अगर आपको पता नहीं है केसेस, तो फिर आपको फिर मालूम होना चाहिए।
I'm aware of.
नहीं तो देखिए ना, ये बात बिल्कुल नहीं चलेगी
ये नहीं, ठीक
कि पे तो हम इतनी बारीक बीनी से देख लें और वहाँ पिटिशनर्स आने के लिए तैयार ही नहीं है, तो फिर हम उनके फिर बेनिफिट्स भी देखेंगे। अगर आपको सिर्फ जुरिस्डिक्शन की बात है और किसको इख्तियार है केस का, तो फिर वहाँ भी हिम्मत करें, वहाँ भी आइए ना। और आप भी नहीं एड्रेस करेंगे क्योंकि आप के लिए एम्बेरसमेंट होगा या हमारे लिए एम्बेरसमेंट होगा, हमें कर दें एम्बेरसमेंट, हमें कोई फिक्र नहीं है। हम आइन और कानून के मुताबिक या चलेंगे या नहीं चलेंगे। अब बहुत हो गया इस मुल्क खिलवाड़ होता जा रहा है कि जी ये तो नहीं कर सकता है पार्लियामेंट, हम जो मर्जी करें। भाई मास्टर रोस्टर भी बना दिया, फिर हमने कोई और चीज़ भी कर दी। कौन से इख्तियारात जो आइन में दिए गए हैं इस्तेमाल किए गए? ऐसा भी ऑर्डर हुए हैं कि जजेस को रिस्ट्रेन किया गया है कि आप केस नहीं सुन सकते। ये कौन सा इख्तियार आ गया है? ऐसे आप देखिए, या तो फिर आप हवा में बातें करें। ये सारी जो बातें हुई थी एक तरीके शायद पार्लियामान ने किया है कि जी आप बात नहीं करना चाहते, मैं कर सकता हूँ क्योंकि मैं चीफ जस्टिस हूँ, मेरी इख्तियार की बात हो रही है, चलें किसी को बुरा नहीं लगेगा। और वो भी मसले, वो उसमें किधर से जुरिस्डिक्शन आ रहे हैं, ज़रा समय हमें समझा दें। वो कौन सा जुरिस्डिक्शन इस्तेमाल किया? इतनी 4-5 दिन से 40 घंटे हम बहस सुन चुके हैं, मगर वो किसी में हिम्मत नहीं पकड़ी पिटिशनर की साइड से कि बात कीजिए जी आपने कैसे जुरिस्डिक्शन इस्तेमाल किया। फिर आ जाती है बात मेलिफिडे और बोनाफिडे की, फिर क्यों नहीं वहाँ इस्तेमाल किया? अगर आप इतने हमारे मुहाफिज हैं तो हर लिहाज से मुहाफिज बनिए और आइन के मुहाफिज बनिए। हमसे पहले आइन के मुहाफिज बनिए, और कि ये वाला भी इख्तियार गलत था तो वो वाला भी इख्तियार गलत है और अब ये वाला भी इख्तियार गलत है, ऐसे फिर आर्ग्यू करें। ये नहीं हो रहा है हमारे सामने। तो देखिए जब इतनी हम जा रहे हैं बातों का, जब वो उसको नज़रअंदाज कर दो, मगर ये बारीक पॉइंट को हम ज़रूर देखें। वो ज़्यादा मेरे ख्याल में बड़ा पॉइंट है, इस बारीक पॉइंट से उसको तो कोई नहीं बात कर सकता है क्योंकि चैलेंज नहीं हुआ है। अब यही बात हो जाएगी, चैलेंज नहीं हुआ, कौन चैलेंज करेगा? मैं कहता हूँ इख्तियार ही नहीं है। मेरी सोच ये है, जब इख्तियार ही नहीं है तो चैलेंज करने की ज़रूरत ही क्या है? quorum non judice हो जाता है फिर। तो ये बातें देखें, ये इसका आपको बस हम उलझाए रखें बारीकियों में, और मोटी बातें आप भी नहीं करें और ना पिटिशनर के कोई वकील करें ना कोई और करे। आप इतने अच्छे वकील हैं, नहीं कर रहे हैं।
I want to on this note, I want to read out a paragraph from
एक वक्त
District
आ
Bar
गया है कि
Association, Rawalpindi
अब मुल्क को आगे बढ़ना है। ये जो इस्तेमाल हो रही है ना अदालतें, वो कहते हैं ना ड्यू प्रोसेस, मिसयूज ऑफ ड्यू प्रोसेस, ये भी तो है ना। ये हमारे कंधे पे बंदूकें रख के चलाई गई हैं और मार्शल लॉ एंडोर्स किए गए हैं। अंग्रेज़ों की हम बात करें, पहले अंग्रेज़ चीफ जस्टिस थे कॉन्स्टेंटाइन, उनका फैसला मौलवी तमीज़ुद्दीन के फेवर में था जमहूरियत के। वो अपने फैसले में इस्लाम की बातें कर रहे हैं, क्रिश्चियन जस्टिस कॉर्नेलियस। वहाँ हम कहते हैं नहीं, हमें तो नहीं पसंद इस्लाम, हमें तो वही मलका जो इंग्लिस्तान की उसी के ताबे हमें रहना चाहिए। इंग्लिस्तान का जज कह रहा है जस्टिस कॉन्स्टेंटाइन कि ये गलत इक़दाम हुआ है, हमारे जज साहब कहते हैं। तो ये अब सब चीज़ों को आप बस एक बारीक नुक्ते को पकड़ के बैठ जाएं तो ऐसे बात नहीं बनेगी ना। ये हमें इज्जत करना चाहिए इंस्टीट्यूशंस की, हमें डेवलप करना चाहिए इंस्टीट्यूशंस। हमारे इंस्टीट्यूशंस परफेक्ट नहीं हैं, मगर हम कहें नहीं हम गलती करेंगे तो आपकी मजाल नहीं, हमारी तरफ आंख उठा के देखिए। कोई और ज़रा सी भी कुछ बात करे जो उसके शायद तो बेहतरी के लिए जा रहा है, नहीं उसको तो हमने सरजनिश करना है। तो देखें, अगर आप करना है तो आप बैलेंस अप्रोच रखिए। आप अटॉर्नी जनरल फॉर पाकिस्तान है। एट द मोमेंट यू आर एन ऑफिसर ऑफ द कोर्ट, not just representing the government's position, because there is no government in the sense कि जिस गवर्नमेंट वो जो थी, अब तो हम केयरटेकर गवर्नमेंट में आ गए ना, तो इन द सेंस कि एक न्यूट्रल सेटअप है। तो आपको पाकिस्तान को मद्देनज़र भी रखिए। मैं आपके वो जो लफ्ज़ है ना अटॉर्नी जनरल फॉर पाकिस्तान, उस तरफ आपकी निशानदेही करना चाह रहा हूँ। आप कोई पार्लियामेंट के मेंबर नहीं हैं। जिस तरह से हम आपसे सवाल पूछ रहे हैं, भाई पार्लियामेंट ने बना दिया, आप क्यों बैठ करके हर चीज़ का जवाब दें? भाई जिसको अटैक करना है वो बताए कि ये गलत है, आपने क्या उसको दिफा करना है? आपने तो कानून नहीं बनाया है। हुकूमत और पार्लियामान में फ़र्क होता है। हुकूमत बेशक मेजॉरिटी हुकूमत एक कानून बनती है, मगर हो सकता है हुकूमत के खिलाफ पार्लियामेंट कानून बना ले। अभी हमें पता नहीं किसके खिलाफ है और किसके फेवर में, अभी तक इस पर ही बहस नहीं हो रही है। कानून तरीक़ेकार गलत है। तो हमारा तरीक़ेकार जब हम बेंचेस के फैसले आगे पीछे कर लेते हैं, 4 जजेस को बिठा करके 5 जजेस को, वो बिल्कुल ठीक है। वो कौन सा इख्तियार इस्तेमाल हुआ है? अगर आप इतनी बारीकी में जाएंगे, आप उसको अवॉइड कर रहे हैं। वहाँ मैं आबिद साहब को भी कहता हूँ, क्यों नहीं बात करते इन चीज़ों पे? सदर है ना सुप्रीम कोर्ट बार एसोसिएशन के, नहीं है बात करेंगे? वाई? ये सवाल छोड़ रहा हूँ मैं। आप एड्रेस करना चाहें करें, नहीं करना चाहें ना करें।
I'll read one paragraph from District Bar Association Rawalpindi for your lordship.
जी साहब, उससे पहले एक सवाल मैं ऐड करता हूँ।
ये मुझे पढ़ने दें, फिर उसके बाद
एक सवाल इसी
अब हमें मजबूर कर दिया ये बात कहने के लिए। मैं बड़ा खामोशी से बैठा हुआ था, सुन रहा था बात, आप इतना भी ना मजबूर करें कि हमें ये बात करना पड़ जाए।
और
कर दिया बात।
ऑनरेबल चीफ जस्टिस की बात को बढ़ाते हुए, एजी साहब, चीफ जस्टिस की बात को बढ़ाते हुए, देखिए मुझे जो मैं समझ दिन के आर्गुमेंट्स है, इस पे शायद सब मुत्तफिक हैं कि पावर सुप्रीम कोर्ट के इन्हांस कर सकते हैं, और वो एंट्री 55 पढ़ते हैं, और एंट्री 55 के इख्तियार पार्लियामेंट के पास है। क्या जो हमारी रूल्स है उसके तहत ये जो इनलार्जमेंट ऑफ जुरिस्डिक्शन और कन्फरिंग देयर ऑन सप्लीमेंटल पावर, क्या ये हम रूल्स के तहत कर सकते हैं?
Lord, your rules are what they are. They are practice and
हाँ या ना में जवाब कर सकते हैं एज पर कॉन्स्टिट्यूशनल लॉ।
the power, the Supreme Court's powers, जो constitutional powers Supreme Court exercise कर रहा है, it is a constitutional court. वो
मैं रूल की बात कर रहा हूँ, रूल्स की। क्या रूल के तहत हम अपनी पावर बढ़ा सकते हैं?
My lord, my respectful submission is that as far as your powers under the Constitution are concerned, your jurisdiction and powers under the Constitution are concerned, those cannot be altered with or even enhanced by the court through the rules. That has to happen through legislation. Now, as far as practice and procedure is concerned, that, in my submission, if anything which which deals with or relates to practice and procedure of this court, that is something that this court can or does deal with.
An argument was submitted yesterday by Mr. Faisal Siddiqui, relying on entry 55. A categorical statement was made that if Section 5 is constitutionally valid through Act of Parliament, meaning giving right of intra-court appeal, that can be done by the Supreme Court in rule-making power also. And that is a categorical statement that was made. What would you respond to that?
And what that was his. He was representing a political party which is part of the vote. My submission.
That's a submission before the court.
I what I am submitting as Attorney General is that
Learned Attorney General, there
power
was
of the
also,
court flows
in
from
the context of very articulately, my learned brother Justice Munib's judgment, where he's made a distinction between a right of appeal conferred relatable to an entry and a general right of appeal, which will be procedural in nature in intra-court appeal.
And that's why I had submitted that if there is anything which is concerning the practice and procedure of this court, the court deals with it and has dealt with
I'm
it by
asking a
providing an
specific
appeal.
question.
But
मेरे
as far
सवाल का
as
कुछ जवाब नहीं मिलेगा ना।
मैं उस पे आने लगा हूँ,
आएंगे नहीं आप कभी।
इस वक्त I am bombarded
और
with questions.
मैं
अब
खसूस
I want to read out
पिटिशनर
it.
से मुखातिब होके कह रहा हूँ।
एक पैराग्राफ पढ़ना चाहता हूँ।
जरा अगर आप
2015 Supreme Court
अगर आप बिफोर यू रीड दैट, अगर आप एक दफा एंट्री 55 को फिर से जरा देखिए और आप ये बताएं कि जो स्टार्ट होता है jurisdiction powers of all courts except the Supreme Court, ये कौन से आपके ख्याल में jurisdictions और powers हैं?
My lord, the courts, the powers.
लिस्ट में
जी नहीं, लिस्ट के अंदर जो सारे मैटर्स
देखिए ना,
हैं
आपने
in relation to the matters
जब आप
in the list,
इनलार्ज करेंगे तो वो तो आप किसी चीज को आप उठा के इनलार्ज कर रहे हैं ना। आप किन चीज जरा इस पे आपके ख्याल में जब वो एंट्री रोक रही है, साथ उनने एक्सेप्शन दिए, आप एक्सेप्शन को रूल बना रहे हैं और रूल को एक्सेप्शन बना रहे
जो एनलार्जमेंट होगी
नहीं, पहले बताएं कि एक्सेप्शन किस चीज की है, पहले उस पे आ जाए। कोई एग्जांपल दे दें हमें कि जी सुप्रीम कोर्ट की ये चीज नहीं हो सकती।
सुप्रीम कोर्ट जो है, सुप्रीम कोर्ट की जितनी भी जुरिस्डिक्शन एंड पावर्स हैं वो फ्लो कर रही हैं कॉन्स्टिट्यूशन से, वो कानून से, वो कॉन्स्टिट्यूशन खुद ही वो उसको क्रिएट कर रहा है और बना रहा है। हाई कोर्ट फॉर एग्जांपल,
अभी वहां प्लीज
मैं उसको बताना जरूरी
मैं सिर्फ आपसे जो पूछ रहा हूँ प्लीज, पहले आप ये बताएं कि जो वो रोक रहा है कि हम लोग जो सारे आर्ग्यूमेंट्स आ रहे हैं वो आ रहे हैं कि जी ये आप एक्सेप्शन देखें, दैट एक्सेप्शन हर जो काउंसिल आए हैं उनने उसे एज अ रूल लिया है। मैं आपसे पूछ रहा हूँ कि जो कमांड ऑफ द कॉन्स्टिट्यूशन है, जो कि चीज रुकवा रही है, वो कौन सी जुरिस्डिक्शन होगी आपके ख्याल में?
जो कॉन्स्टिट्यूशन कह रहा है, कॉन्स्टिट्यूशन व्हेन वी रीड दिस एक्सेप्शन एंड एज आई हैड सबमिटेड, वी रीड दिस एक्सेप्शन विद द लास्ट parts, last two sentences, enlargement and supplemental bit. I have.
How long will you take?
जरा आप इस पे सोच लें, हम जरा
इस तरह पूछ रहे हैं आपसे। अगर थोड़ी सी बात है तो
Dare
हम
not answer this
No,
question.
no, no, एक second. I know it's very difficult for someone to answer when you face with a lot of
मैं
questions.
तो इस सवाल
नहीं,
के जवाब
एक
देना
सेकंड, अगर थोड़ा सा वक्त है तो हम रिकन्वीन कर सकते हैं. अगर लंबा वक्त है, हम आपको रोकना नहीं चाह रहे, तो फिर हम कल कर सकते हैं कंटिन्यू या
I can conclude my submissions.
in how long?
If you give me, let's say, half an hour. अभी
तो
दे
फिर
दो।
ऐसा करते हैं कि फिर हम आधे 2:30 बजे तक ब्रेक कर लेते हैं, फिर वापस आते हैं, फिर आज फिर आप खत्म कर
So
लीजिए.
when I come back,
Learned
my
Attorney
lord,
General.
आप ये नोट कर लीजिए.
आपका वो भी नोट कर लिया और आपका भी मैंने
वो आप
आप अपने सबमिशंस पूरे कर लें, एंड में सुना.
नहीं, ये आपको
नहीं नहीं नहीं, प्लीज नहीं, आप अपने सबमिशंस पहले पूरे कर लें. दिस क्वेश्चन कैन वेट.
Learned Attorney General, another question related to what my brother Justice Afridi has stated just now. Once the Parliament has exercised its competence and has enlarged the jurisdiction, can it take it away? Can it repeal? That is a question, because then the entry does not give the competence of curtailing the jurisdiction. So once a jurisdiction has been conferred to an act of Parliament, as I understand, that can't be taken away.
I agree, sir.
So that is why the distinction between the first portion and
I'll
the
address
And
this
also
when
whether
addressing
at all it's conferring a new jurisdiction.
That is
It
something
is simply enlarging a 184.
existing jurisdiction,
Existing jurisdiction.
unlike any additional.
And may I add?
Full court.
No. When you're reading it, entry 55, the way you're reading it, then actually, why are you looking for competence 191? Then you would say just look at 142,
Entry
come
55
straight to
सिर्फ-
55 और enlarge कर दो.
ये सिर्फ अपील के लिए है।
तो अपील के लिए ही, फिर
नहीं, तो
आप 191 में
आप जवाब
competence
ना
क्यों
दें,
ढूंढ
आप
रहे हैं?
सुनते रहे ना, फिर लिख लीजिएगा, फिर हम आते हैं ना
आप
वापस.
competence
2:30
वहाँ क्यों
बजे.
ढूंढ रहे हैं?
और I will just add, ये जो NT 55 है, इसके दो portions.
My lord has had quite a time to think about it. I saw that.
Jurisdiction and powers of all courts, so except वो जो है Supreme Court ने, क्योंकि Supreme Court का उन्होंने acknowledge किया है कि हमारे पास power नहीं. Jurisdiction and power of all courts with respect to any of the matters of this list. ठीक है जी? This deals with all courts. Supreme Court की special treatment है because it has all sorts of constitutional jurisdiction. So to the extent of the Supreme Court, उन्होंने कहा है, the enlargement of jurisdiction of the Supreme Court and the conferring of thereon on supplemental powers. ये जो power है, this has to have express authorization. बाकियों के लिए आपको
I know
express
my lord's view.
authorization की जरूरत
because
नहीं है.
my lord has expressed his view in the judgment,
Yes.
Ghulam Muhyiddin.
तो
So
उसको आप
that is
देखिए।
what I was distinguishing.
और
चलें?